2 years ago. Parole. Yes.
Matter was ordered to be posted on 2nd April.
Huh.
They didn't post it. In spite of file was sent to them.
Yav fresh matter ಏನು?
Fresh matter.
Monday ಕೊಡಿ.
Monday, kindly strictly.
Monday.
They are telling, my lord, they are.
Monday. Yes.
My lord, this is
Wait, you can't come forward. Be there. ಎಲ್ಲಿದ್ದೀರಾ ಅಲ್ಲಿರಿ ಹಿಂದೆ. Second row ಅಲ್ಲಿರಿ.
I was here only.
Yes. Fresh matter, personal matter. First time matter. ಕೊಡಿ. Monday ಕೊಡಿ. Monday, according to seniority, it will come. Give it.
My lordship, one police protection matter. My lordship, the urgency is my lordship. Some miscreants had burned the entire house, my lordship.
2:30.
Yes, my lordship.
Respondent is the impleading applicant, Your Honor. Respondent corporation
Give
has
it. Yes.
posted on Monday.
No date. Yes, give it. It's a pending matter.
The court, the procedure has order, passed the order to remove from the worksheet,
Remove the.
to remove the Archaka of the temple, the Mujrai temple. I am not heard in the matter. Suddenly, my lord, order has been passed without hearing me and behind my back. They
Fresh
are
matter.
on the store, fresh matter.
Monday.
They are on the door, my lord.
They are on the door. ಆಯ್ತು ಕೊಡಿ.
So they are
2:30.
2:30.
Tender matter, tender condition is being done. The identical tender condition, Dharwad High Court permitted, relaxed the tender condition and permitted the petitioners therein to participate. I'm seeking for a similar order.
2:30. Fresh
Fresh, ಇದು fresh.
FR ಇಲ್ಲ.
FR, just for.
Comply ಆದರೆ ಮಾತ್ರ ಬರೋದು.
Such-
And today there is a reference at 4 PM. If it comes by 3:30, we'll take it. Otherwise tomorrow. Vacating stay ಹಾಕಿದ್ದೀರಾ? Vacating stay ಹಾಕಿದ್ದೀರಾ? ಕೊಡಿ. We'll see. We'll post it. Give it. Fresh matter. Stay ilva. List in 2026. Yes. Stay ಇದನ್ನು ಕೇಳ್ತಿರಲ್ಲ. 2:30. Possession ಯಾವಾಗ ಆಗಿರೋದು ಆರ್ಡರ್? ಕೊಡಿ 2:30. Wait. Yes. Monday. Tuesday, we'll take it on Tuesday. Yes. Fresh pending. Vacating stay ಅಂದ್ರೆ next Wednesday ಬರುತ್ತೆ ಕೊಡಿ. ನಾಳೆ ಅಂತೂ ಆಗಲ್ಲ ಮೇಡಮ್. There are already 150 matters. Tomorrow I can't. Yes. Give it. Yes. No, Monday pending ilva illa. Tuesday or Wednesday it will come. There are extension of parole. ಯಾವಾಗ expire ಆಗೋದು? 2:30. Yes, next. Pending. Give it. Pending. Give it.
Your lordship, fresh matter,
We'll
criminal
post it.
pity, criminal
Back page ಇರೋದೇ 3 ದಿನ.
Millards orders ಗೆ ಅಂತಿತ್ತು Millards 18th date given matter.
ಏನ್ ಆರ್ಡರ್ಸ್ ಗೆ?
IMLA Millards.
ಸ್ಟೇ ಇಲ್ವಾ? ನೋಡೋಣ. Yes.
Your lordship, criminal petition matter, I am for accused number 4 and 5. Accused number 1 to 3 stay has been granted by your lordship. So similar matter, your lordship.
17th. Yes.
This is a Senior Citizens Maintenance Act.
Huh?
Matter is under Senior Citizens Act.
The
Assistant Commissioner.
pending of fresh sir.
R1, R2 emergent notice served.
ಕೊಡಿ ಬರೋಣ. Give it. Yes. Next.
Millards the fresh GM police matter Millards there is threat of dispossession Monday Millards.
GM police ಅಲ್ಲಿ ಯಾರು police and dispossess ಮಾಡ್ತಾರಾ ನಿಮ್ಮನ್ನ? Don't tell me all this.
Order Millards by the trial court directing Millards the jurisdictional police Millards to protect the petitioner hearing Millards.
Police protection ಕೇಳಿ likely to be dispossessed. Which policeman will dispossess you will see?
Millards the others Millards the respondents Millards are private respondents.
That's all right. Give it. Yes.
Monday
Your
Millards.
lordship, rowdy sheeter has been ordered, your lordship. There's
What?
only one matter.
Rowdy sheeter.
Has been
Monday.
ordered.
Pending matter, Tuesday.
ಕೊಡಿ pending memo ಕೊಡಿ.
My lord,
Tuesday.
memo matter.
There is no stay.
Wait.
2024 matter, my lord.
Give it.
Millards vacating stay Millards.
Vacating stay ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Fresh matter, Millards.
ಈಗ ಒಂದು ಕೊಟ್ರಲ್ಲ ಏನು every row you have a case, is it? Every row you have a case?
My lords, I had two memos, my lord, before I could say my person is.
Yes.
I already have a tender, my lords. Despite that, DVMP is now calling for fresh tender in respect of that. My contract is valid till October.
2:30.
My lords, attachment warrant has been issued against.
Yes. Monday. Sir. ಏನಾಗಲ್ಲ ಕೊಡಿ ಮಂಡೆ, ಸುಮ್ಮನೆ ಎಂಥದ್ದು ಇರಲ್ಲ ಅದು. ಹ್ಯಾಂಡಲ್ ಆಗತ್ತೆ ಕೊಡಿ, ಬರುತ್ತೆ ಕೊಡಿ. ನೆನ್ನೆ ಸಾಯಂಕಾಲ ಆಗಿರೋ ಆರ್ಡರ್ ಎಲ್ಲ ಇವತ್ತೇ ಸಿಗೋದು. Keep it. Yes. Give it. Yes. Give it, sir. No problem. Yes. Next 17th. So what, take adjourn. Framing of charge tomorrow.
My lordship.
Who is that in the middle? Yes. Position will be taken. Fresh matter. 2:30. Yes. Huh? Monday ಅಂದ್ರೆ ಎಲ್ಲ ಎಷ್ಟಾಗುತ್ತೆ ಗೊತ್ತಿಲ್ಲ, ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಹಾಕಿ ಪೆಂಡಿಂಗ್ ಮೆಮೋಸ್ ಎಲ್ಲ ತಗೊಂಡ್ಮೇಲೆ ಇದು. ಎಸ್. ಪೆರೋಲ ಕೊಡಿ 2:30. ಪೆಂಡಿಂಗ್ ಅಲ್ವಾ ಮಂಡೇ? ಹೋಯ್ ಆಯ್ತು. 2:30 ಎಷ್ಟಾಗಿದೆ ಮೇಡಮ್? 2:30 2:30 ಪೆಂಡಿಂಗ್ ಮೆಮೋ ಕೊಡಿ. ಗಿವ್ ಇಟ್ ಮಂಡೇ.
Fresh matter.
ವೇಟ್, ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಹೇಳ್ಬೇಡಿ. ವೇಟ್. ಎಸ್. ಮಂಡೇ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಪರೋಲ ಯಾವಾಗ ಎಕ್ಸ್ಪೈರ್ ಆಗುತ್ತೆ? ಟುಮಾರೋ. ಎಸ್.
Fresh matter, my lords. Senior citizenship act.
My lordship, regional passport authority have rejected my passport.
Give it. Fresh
The
matter.
lower pending matter, my lordship.
Fresh matter, my lords. The petitioner has been tenant in the Muzrai premises, my lords. They have locked the premises.
2:30.
For 2:30, was the second round of repetition. Was earlier, the land was reserved for the sewage treatment plan.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನ್ ಹೇಳಿ?
Now they have withdrawn the earlier order, my lords, and now they have placed the right to hand over the property, my lords, for construction.
Give it. Tomorrow 2:30. ನೀವ್ ಯಾಕೆ? ವೇಟ್.
Dispose of the matter yesterday.
Which one?
Memos of police protection, my lords.
My
lords, there is already a civil court order.
No, that I don't know.
Civil court that they did not.
Whoever is there.
My lord, there's a civil court order for them. They did not make their parties, my lords. Makers.
ಇವತ್ತಿನ 3rd to 5th ಅಲ್ವಾ ಇರೋದು?
My lords, there's an order by civil court where we are parties, my lords. They did not. I mean, we have informed.
Who knows?
Yes. My lords, and they suppressed it, my lords. They suppressed it, my lords.
ಯಾರು ಬಿಪಿನ್ ಹೆಗ್ಡೆ ಅಪಿಯರ್ ಆಗಿದೆ?
We have informed, my lords, and informed, my lords.
In that suit. State is not a party.
There is an undertaking given there.
Where, who was given undertaking?
The petitioner. Petitioner
All right.
for the party given
ಅದು ಯಾರೋ ಮಾಡ್ಲಿ ಬಿಡಿ, ಈಗ ಹರಕೆ ನೇಮೋತ್ಸವ ತಾನೆ.
order, my lords. Civil court.
You don't know.
Appeal is also pending. They suppressed everything and obtained order. Now they want to take over, my lords. And
ಆಯ್ತು, you tell him and move it.
I have informed.
ಕೊಡಿ ನೋಡಿ.
2:30, please, my lords. Because
Being spoke, ಇವತ್ತು 4 ಗಂಟೆವರೆಗೆ ಮಾತ್ರ 4 o'clock ರೆಫರೆನ್ಸ್ ಇದೆ. 3:45 we have to get up. ಅಷ್ಟರಲ್ಲಿ ಬಂದ್ರೆ ಸರಿ, ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಅಷ್ಟೇ.
I have filed IA for vacating.
We'll see. ಇನ್ನು ಒಳಗೆ ಬಂದಿಲ್ಲ ನೀವು, ಆಗ್ಲೇ IA for vacating.
Please, 2:30.
We'll see. Yes.
Fresh matters, my lord. GM forest matters, my lord. Related matters stay has been granted for Monday, my lord.
An attachment warrant has been issued without serving notice upon us, my lord.
2:30.
My lords, kindly have it for tomorrow, my lord.
No, tomorrow. 2:30 or Monday.
Bishop cooperative 26 ತನಕ ಟೆಂಡರ್ ಇದೆ ಸರ್. ಅದು ವಿತೌಟ್ ನೋಟಿಸ್ ಫ್ರೆಶ್ ಆಗಿ ಟೆಂಡರ್ ಕರೆದಿದ್ದಾರೆ.
ಯಾವಾಗ ಕರೆದಿದ್ದಾರೆ?
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ.
ಯಾವಾಗ ಕರೆದಿದ್ದಾರೆ? ಮಂಡೆಗೆ ಹಾಕಿ.
For vacating stays.
Give it.
For Monday, my lord.
No.
My lord.
No.
Next week.
Consider for setting up a fuel station, my lord.
Give it. Yes.
Activities have already been started.
Give it, sir.
2:30, my lord.
2:30.
Construction activities have already been started, my lord.
So what? ಏನು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮುಗಿದೋಗುತ್ತಾ ನಾಳೆ ಒಳಗೆ? Nothing. Monday. Yes. Give it, sir.
My lords, this is a fresh matter. 3.5 crores have been illegally held by respondent number 2, my lords.
ಕೊಡಿ.
Please, your lordship.
Who are you? Huh? Why are you moving a memo? Yes. 2:30. Monday, yes. Monday.
The lordship yesterday has allowed the petition regarding retention of that.
So
Only the timing your lordship may mention.
What
between
timing?
4:30 in the evening of 3rd till 6 a.m.
ಅದ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಅವ್ರಿಗೆ. You get Shanti Bhushan, yes.
My lords, it's a pending matter, my lords. I filed an IA for
ಅವ್ರು ಕರ್ಸಿ,
vacating.
ಅವ್ರ ಮುಂದೆ ಏನ್ ಹೇಳ್ಬೇಕು ಹೇಳಿ.
I filed an application for vacating of stay, my lords.
ಕೊಡಿ, yes.
Fresh matter, my lord.
Give it.
Issuance of self-evident.
Give it,
My
give it.
lordships,
Request one matter for 2:30, my lord.
Give
my
it.
lord. My lordships, this is for withdraw the parole applications and to file the fresh applications, my lordships.
ಫ್ರೆಶ್ ಹಾಕಿ ಯಾವ್ದು ವಿಡ್ರಾ ಮಾಡಬೇಕು, ವಿಡ್ರಾ ಎಲ್ಲ ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್.
I request one matter for 2:30.
Today, my lordships,
We'll see, yes.
much obliged, my
Constructing a temple,
lordships.
my erstwhile SC, my lord, is creating trouble. Only petition, my lords, for police protection. Lordships are directed the registry to list it today.
We'll see, yes.
Lordships may kindly have it at 2:30.
2:30 ತಗೊಳ್ಳಿ. 2:30 ಎಷ್ಟಾಗುತ್ತೆ ಗೊತ್ತಿಲ್ಲ ಇವತ್ತು.
Take it, ma'am.
Yes.
So very good.
ಎಷ್ಟಾಗಿದೆ 2:30? None of them will be taken up. 3:45 to get up. Yes. ಅಷ್ಟ್ರಲ್ಲಿ ಬಂದ್ರೆ ಅಷ್ಟೇ. Yes, sir.
I know, sorry. Greatest difficult repetition I'm making this. On final hearing on 71 ಹಾಕೊಂಡಿದ್ದೀವಿ. ಇವತ್ತು ಆಗೋದಿಲ್ಲ.
71.
71. What has happened is, it relates to my lord, the sugar, packing of sugar, my lord, in, excuse me. Packing of sugar, my lord, in jute bags.
Final disposal.
Final disposal.
ಇದು ನಾನ್ ಹಾಕಿರೋದಲ್ಲ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್. ಅರ್ಲಿಯರ್ ಬೆಂಚ್ ಇರಬೇಕು.
ಅವಲ್ಲ. 2:30 ಅಂತಿತ್ತು. Any date convenient to your lordship, because my lord, there's a direction by the Supreme Court for disposal in my lord November itself. ಅದು ಬಂತು ಆಮೇಲೆ ಆಗ್ಲಿಲ್ಲ. ತಮಗೆ ಯಾವತ್ತಾಗುತ್ತೋ ಬರ್ತೀನಿ.
Bill number 71 correct?
71.
ಅಲ್ಲ, it's not at 2:30 final disposal ಅಂತ ಇದೆ ಅಷ್ಟೇ.
ಹೌದು. ಅಲ್ಲ, ಇದು ಹಿಂದೆ 2:30 ಅಂತೇಳಿ ಹಾಕೋತಾ
ಆಯ್ತು, ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು ಹೇಳಿ.
ತಮಗೆ ತಾವು
ನೆಕ್ಸ್ಟ್ ವೀಕ್ 3 days, ಅದರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ 3 days ಇರೋದು. ಓನ್ಲಿ 22nd 23rd ಆ ವೀಕ್ ಮಾತ್ರ ಆಗ್ಬೋದು. ಅವಾಗ ಅಂದ್ರೆ ಐ ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್ ಆನ್ 22nd at 2:30.
ಇದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ಟ್ರೈ ಮಾಡಬಹುದಾ?
That is,
I know my lord,
16th
ಆಗ್ಬೋದು. I
16th
try, my
at
lord, be
2:30.
here, subject to your lordship's convenience.
Yes.
I know, I understand.
Yes.
ಇದು ನಾವು,
You are appearing for the petitioners.
yes, with the greatest repetition I am making this
That's all-
submission. I
that's
know
all
the
right.
amount of,
Yes. 16th at 2:30.
please.
Yes.
Fresh matter, still number 1.
What early hearing? Admit ಆಗಿದೆಯಾ ಕೇಸ್? ಯಾರು ಹಾಕಿರೋದು early hearing? ಯಾರು ಹಾಕಿರೋದು early hearing? ಅದು ಕರ್ಗ ಆಮೇಲೆ ಕೇಳ್ತೀನಿ. early hearing ಯಾರು ಹಾಕಿರೋದು?
ನಾವೇ ಹಾಕಿದ್ದು.
ಯಾವಾಗ early hearing ಹಾಕ್ಬೇಕು ಅಂತ ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ವಾ?
ಲಿಸ್ಟ್ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ.
ಯಾವಾಗ ಹಾಕ್ಬೇಕು?
I'm sorry.
Issue rule post for hearing in usual course ಅಂದಾಗ urgency ಇದ್ರೆ early hearing ಹಾಕ್ಬೇಕು. I am seeing every day 20 early hearing applications. What is that you are going to achieve?
In a lighter way, some court they insist to make an application for early hearing to get the matter listed.
Yes.
That is the reason why.
ಈಗ ಏನ್ ಹೇಳಿ ಈಗ?
ಕರ್ಗದು. ಈಗ ಒಂದು
23
ಹೊಸದಾಗಿ ಆರ್ಡರ್
order
ಮಾಡಿದ್ದಾರೆ. Subject to result of this writ petition, again he is permitted to carry karga. And he is relying upon the earlier order, which is
I told you, if the
Please, my lord,
Tahsildar is playing smart,
No, my lord,
will take care. Yes.
The first thing is, he is climbing in a hereditary achaka.
Who had performed karga earlier year?
ನಾನು 3 ಸತಿ ಮಾಡಿದ್ವಿ.
ಯಾವಾಗ?
My lords, I have got a list. I'll just enlighten my lords.
23, my lord,
My
he
lords, I'll
performed.
just say date wise. 2011 Chandappa, 2012 Chandappa, 2015 Chandappa, 2017 Chandappa, 2022 Chandappa, 2024 Chandappa. Ramesh, my client, 2016, 18, 2023.
May make one submission, my lord. So far as permission has been granted in favor of the Ramesh, my lord, to carry karga 16, 18 and 23. In all the 3 occasions, he is not in a position to carry karga from outside of the temple. He fell down in the temple premises.
Where is the report?
My lord, I have produced the
Where is the report?
paper cuttings as well as, my lord, the video footage, my lord. Also, my lord, I have produced before the Tahsildar during the course of, my lord, the meeting.
Only two persons are eligible, my lord, Ramesh and Chandrappa. Ramesh, he cannot.
Now the tussle is between Ramesh and
And
Chandra.
Ramesh is,
How
my
old
lord,
is Ramesh?
Ramesh is overweighted, above 100 kg, my lord. He is not in a position to walk freely.
So you are very slim and fit.
In spite of that, my lord, he has produced the certificate, fitness certificate issued by the district surgeon.
Who?
Ramesh.
Even Ramesh.
Therefore,
FIR
my lord,
also
I requested before the, my lord, in the meeting held before.
Where is the order of the Tahsildar?
My lord, I'll enlighten.
Tahsildar order kodi.
My lord, I'll just Arjunappa hereditary Archaka.
ಅದೆಲ್ಲ ಬಿಡಿ.
Arjunappa ಮಗ
That's all.
ರಮೇಶ.
ಅಲ್ಲ,
ರಮೇಶನ ಮಗ
ಅದೆಲ್ಲ
ಮನೋಜ್.
ಪರವಾಗಿಲ್ಲ. ಈಗ ನಿಮಗೆ ಎತ್ಕೊಂಡು ಹೋಗೋ ಶಕ್ತಿ ಇದೆಯೋ ಇಲ್ವೋ?
Sir, that has been, we are.
I have not enlightened, my lord.
Number 11, my lord.
Page?
Page number 11.
Of the order,
Please, my lord.
ಹೇಳಿ ಸಚಿನ್. Yes, tell me.
ಮನೋಜ್ ಕುಮಾರ್ ಇದ್ದಾರೆ ಮೊಮ್ಮಗ, ಅವರು ಅರ್ಜಿ ಹಾಕಿದ್ದಾರೆ.
ಯಾರು ಆಗ್ಲಿ ತಗೊಂಡೋಗಕ್ ಆಗುತ್ತೋ ಇಲ್ವೋ ಅಂತ.
ತಗೊಂಡೋಗ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ, ಕೊಟ್ರೆ ಅವಕಾಶ ಕೊಟ್ರೆ ಅಲ್ಲ.
Unmarried, my lord.
ಚಂದಪ್ಪ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಕ್ಲರೇಷನ್, ಇವ್ರ ಕಮಿಟಿಗೆ ರೈಟ್ ಇಲ್ಲ ಅಂತ ಮುಂದೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಡಿಕ್ಲರೇಷನ್ ಇದೆ. ಅರ್ಲಿಯರ್ ಡೈರೆಕ್ಷನ್ ಹ್ಯಾಸ್ ಬಿನ್ ಓವರ್ ರೀಚ್ ಬೈ ದಿ.
ಎತ್ಕೊಂಡೋಗಿ ಆಮೇಲೆ ಬಿದ್ದೋಗಿ.
ಇಲ್ಲ, ನಾ ಮುಂಚೆ ಮಾಡಿದ್ದೀನಲ್ಲ.
ಯಾವಾಗ
ಮಾಡಿದ್ದಾನೆ.
Where is that? I'm asking the report where he cannot take it ಅಂತಿರೋದು ಎಲ್ಲಿದೆ?
Video.
Where is that report?
My lord.
Shall I place, my lord, the video footage, my lord? At present,
Of what video footage, sir?
My lord, for the year 2023.
Video footage ಯಾವ ರಿಪೋರ್ಟ್ ಇಲ್ಲವಾ?
Report ಎಲ್ಲ paper ಇದೆ. That.
Why Tahsildar behaves like this?
No, my lord.
Where is the report drawn that he is not in a position to do it?
All the earlier paper cutting and even.
He says 2023 was not able to carry it, it fell down or whatever. He fell down. Where is the report of that kind?
No, we are order for that Anjanappa Pujari, my lord, on in the year 2023. But Ramesh carried outside. So the FIR has lodged against the Ramesh. We are not order for Ramesh, my lord.
My lord,
In the year 2023, Anjanappa Pujari, we are
not right is creating and litigation is generating on that.
Ma'am.
ಕೊಡಿ ಇಲ್ಲಿ.
The 23 order.
ಮನಸ್ಸಿಗೆ ಬಂದಂಗೆ ಬರೀತೀರಾ ಎಲ್ಲ.
23 order. That is the.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದು?
Last but one.
ಸಭೆಯಲ್ಲಿ ಹಿಂದಿನ ತಹಸೀಲ್ದಾರ್ ಅವರ ಅಧ್ಯಕ್ಷತೆ ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕ ಯಾವುದೇ ತರಹದ ಅಲ್ಲ, ದಟ್ಸ್ ಆಲ್ ರೈಟ್, ಡೋಂಟ್ ವರಿ ಅಬೌಟ್ ಕೋಡ್ ಆಫ್ ಕಾಂಡಕ್ಟ್. ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದು ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? ಮುಂದುವರೆದು 3-4 ಪತ್ರದಲ್ಲಿ ಮಾನ್ಯ ಆಯುಕ್ತರು ಧಾರ್ಮಿಕ ದತ್ತಿ ಸುವರ್ಣ ಅನುಭವ ಅರ್ಹತೆ ಇತ್ಯಾದಿ ತೆಗೆದುಕೊಂಡು ತಾತ್ಕಾಲಿಕ ಸೂಕ್ತ ತೀರ್ಮಾನ ಆದೇಶ ಉಲ್ಲಂಘಿಸಿ ಕರಗ
23, my lord, it is in favor of
Ramesh. ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ ನಿಮ್ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ?
My lord, sir, just point out.
Internal page 11, my lord.
My lord, sir, just point out, my lord, sir. ಹೊಸ ಆರ್ಡರ್ ತೆಗೆದಿ. ಹೊಸ ಆರ್ಡರ್ ಇಲ್ಲೇ ಇದೆ. My lord, sir, just point out. One by one, I'll point out, my lord, sir. How they overreach the court orders.
1 minute. You overreach ಬಿಡಿ sir. I'm asking about your fitness.
Yes, yes, sir.
First ಅದ ಹೇಳಿ.
Sir, 3 ಜನ ಹಾಕಿದ್ವಿ. ಒಂದು ಅರ್ಜುನಪ್ಪನ ಮಗ ರಮೇಶ್ ಮಗ ಮನೋಜ್ ಕುಮಾರ್. ಅರ್ಜುನಪ್ಪನಿಗೆ ವರ್ಷ ಆಯ್ತು, ನಾನು ಒಪ್ಕೊಳ್ತೀನಿ. ಅರ್ಜುನಪ್ಪನವರು ಹೇಳಿದ್ರು ರಮೇಶ್ ಅಥವಾ ಮನೋಜ್ ಕುಮಾರ್ ಮಾಡ್ಲಿ ಅಂತ ಹೇಳಿ. ರಮೇಶ್ KBL ಎಂಪ್ಲಾಯ್ ಆಗಿದೆ. KBL ಎಂಪ್ಲಾಯ್ ಆದ ಕಾರಣ ಕರ್ಗ ಹೋರ್ಬೇಕು ಅಂತಿದ್ರೆ ಲೀವ್ ತಗೋಬೇಕು 15 ದಿವಸ, ವಿಚ್ ಈಸ್ ಆಲ್ರೆಡಿ ಟೇಕನ್, ವಿಚ್ ಈಸ್ ಆನ್ ರೆಕಾರ್ಡ್. ಮನೋಜ್ ಕುಮಾರ್ಗೆ ಕರ್ಗ ಯಾಕೆ ಕೊಡ್ಲಿಕ್ಕೆ, ಇವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ರಮೇಶ್ ಅವರು ಈಸ್ ನಾಟ್ ಎ ಹೆರಿಡಿಟರಿ ಅರ್ಚಕ, ಆದ ಕಾರಣ ಕೊಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ದಟ್ ಈಸ್ ಒನ್ ಆಫ್ ದಿ ಅಬ್ಸರ್ವೇಷನ್. ಮನೋಜ್ ಕುಮಾರ್ಗೆ ಯಾಕೆ ಕೊಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ನು ಹಿ ಈಸ್ ಎ ನಾಟ್ ಎ ಮ್ಯಾರಿಡ್ ಮ್ಯಾನ್ ಅಂಡ್ ಅನ್ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ಡ್. These are 2 grounds under which Manoj Kumar has been denied with to carry karga. Insofar as Ramesh Kumar is concerned, what they say is that he is not a hereditary archaka. The said observation, said finding is contrary to the direction which is issued in the writ appeal.
No,
Which is that writ appeal?
Grateful.
Page.
My lords, I take my lords to the writ appeal order. That is page number. Writ appeal order. Kindly see page number 148.
155.
My lords may, 148 is the, this thing. My lords may directly go through page number 153. My lords, I take my lords to page 152, para 6. Having heard the counsel for all the parties, we have noticed that on earlier occasion, WP number Tashida Aneka was directed to consider the representation of appellant number 1 and 2, Arjunappa Mate Ramesh. The application of appellant came to be rejected by the Tashildar on the ground that second appellant Ramesh was working as a lineman at Karnataka Electricity Board. Therefore, he is not entitled to carry Karga on the day of festival. It is contended by the respondent that on 1 or 2 occasions, the Karga festival was not taken on the area where the SC/ST people are residing on account
That's
of
all
the
right.
same.
1 minute.
Yes, sir.
Come to page 155, paragraph 7.
Yes, sir.
Yes.
155.
Ashtwadi.
In these circumstances, appeals are disposed of. The order of the Tashildar Anekal dated 3/4/2012 passed in is set aside and modified, holding that said order shall not be precedent for ensuring here if the appellant number 1 and 2 are the hereditary Achakas, if the applications are filed for the next Karga festival by producing all necessary documents, the second appellant to carry the Karga festival shall be considered in accordance with law.
Now, this
Then
is
Supreme
1
Court
minute. This is 2013 order.
13.
ಆಮೇಲೆ ನಿಮಗೆ ಕೊಟ್ಟೇ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಯಾವಾಗ
ಅಲ್ಲ,
ಕೊಟ್ರಿ?
ನನಗೆ ಮತ್ತೆ ಕೊಟ್ಟಿರೋದು 2016 ಅಲ್ಲಿ.
ಆಯ್ತು. ಆಮೇಲೆ
ಮತ್ತೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋದ್ರು ಎದುರು ಪಾರ್ಟಿಯವರು.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ, ಅದು ಬಿಡಿ.
ಆಯ್ತು. ಮತ್ತೆ ಏನಾಯ್ತು, ಪುನಃ ರೊಟೇಷನ್ ಬೇಸಿಸ್.
That is also disposed in the year 2015.
15 sir.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ ನಿಮಗೆ 2016
16 ರೊಟೇಷನ್ ಬೇಸಿಸ್ ಅಲ್ಲಿ ಕೊಡ್ತೀನಿ ಅಂತ ಬರ್ದ್ರು.
ಒಟ್ನಲ್ಲಿ ಕೊಟ್ರು. ಆಯ್ತಾ? ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಯಾವಾಗ ಕೊಟ್ರು?
ಆ ರೊಟೇಷನ್ ಬೇಸಿಸ್ ಮೇಲೆ ನನಗೆ ಒಂದ್ ವರ್ಷ ಸಿಕ್ಕಿತ್ತು. ಆ ರೊಟೇಷನ್ ಬೇಸಿಸ್ ನ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿ ಇನ್ನೊಂದು ರಿಟ್ ಹಾಕಿದೆ, ಪೇಜ್ 557.
ಅದೇನಾಯ್ತು?
ಅದು ನನ್ನ ಪರವಾಗಿ ಆಯ್ತು.
ಆಯ್ತು.
Kindly see the order, page number that is 165. This court has made a
paragraph 7.
Paragraph number 7.
Correct.
Contrary to the order passed by the division judge, is also pertinent to mention that Honorable Supreme Court nowhere directed.
No opportunity was given, ಅದಕ್ಕೋಸ್ಕರ it was sent back.
ಮತ್ತೆ ಪುನಃ ಏನಾಯ್ತಂದ್ರೆ ಮತ್ತೆ ಪುನಃ ಏನಾಯ್ತಂದ್ರೆ 2019 ಅಲ್ಲಿ ನನಗೆ ಪುನಃ ಕೊಡ್ಲಿಲ್ಲ ಅವರು.
ಒಂದು ನಿಮಿಷ. 2016 ಕೊಟ್ರ? ಆಮೇಲೆ
2016 ಸಿಕ್ಕಿತ್ತು.
2018 ಕೊಟ್ರು. ಆಮೇಲೆ 2023 ಕೊಟ್ರ?
ಹೌದು. ಅಲ್ಲ
2023 ಕೊಡ್ಲಿಲ್ಲ.
ಕೋವಿಡ್ ಇರೋದ್ರಿಂದ
ಸಿಕ್ಲಿಲ್ಲ.
23
ಅಲ್ಲ 23 ಅಲ್ಲಿ ಯಾವ ಕೋವಿಡ್?
ಅವ್ರ ತಂದೆ ಕೊಟ್ರು.
ಅವ್ರ ತಂದೆಗೆ ರಮೇಶ್
ಫಾದರ್ ಕೊಟ್ರ?
ಹೌದು.
ದಟ್ ಇಸ್ ಅರ್ಜುನಪ್ಪ.
that he was the ಪೂಜಾರಿ.
ಆಯ್ತು. 2023 ಒಂದು ವರ್ಷ ಸಿಕ್ಕಿದೆ.
ಹಾ.
ಅದಾದ್ಮೇಲೆ
24 ಯಾರು ಮಾಡಿದ್ರು?
24 myself.
That is challenged in the impugned writ petition.
That's all right.
Yes sir. Now kindly see
now
the
whether it is on if it is on rotation, he has to perform.
My lord, for being yes, my lord, being agreed for the my lord at the first instance, my lord, the rotation has been ordered. That order has been called in question before this honorable court. The same has been set aside.
Which rotation order?
ಹೌದು.
ಈಗ ಯಾವ rotation ಇಲ್ಲ?
ಇವಾಗ ಯಾವ ಇಲ್ಲಿ ಏನಾಗಬೇಕಾಗಿದೆ?
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ, ಈಗ ಯಾವ rotation
ಇಲ್ಲ? Committee
ಮತ್ತೆ ಹೇಗ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಈಗ?
My lord, every year, my lord, they are inviting the applications from the person who are the aspirants of the Karga, my lord. This year, my lord, 5 applications are applied. Out of which, my lord, 3 are the members of the petitioner's family only.
All right.
And 1 is, my lord, the representing the particular community. And 1 is, my lord, one more parallel community, my lord. Parallel community held that, my lord, we are not interested. We are let the Arjuna family, my lord, perform the Karga. And so far as, my lord, after holding the inquiry, detailed inquiry, my lord, it is now, my lord, it is granted in favor of the 6th respondent.
On what criteria?
My lord, he performed the Karga for the law, my lord, at 7 times, my lord, without any fault, my lord, without any, my lord, he has carried the Karga successfully. And so far as, my lord,
1 minute, don't you have any guidelines to allot this?
ಇಲ್ಲೇನಾಗಿದೆ?
Why?
ಅವ್ರದ್ದು ಟೆಂಪಲ್ ಗೆ that is separate.
But even ನಿಮ್ಮ women fancy select ಮಾಡಿ ಜಗಳ ಆಗಿರೋದು.
No my lord, he is claiming he is the hereditary Archaka. He has to
ಇಲ್ಲ ಇಲ್ಲಿ ಏನಾಗಬೇಕಾಗಿದೆ?
Commissioner under 25 he has to get an from the deputy commissioner that he is the hereditary Archaka. he has not, till today, he has not get any order from the deputy commissioner.
So
And
he
as
claims to
25
be hereditary heir.
Please, my lord.
But
He
there is
not
already a
a-
finding in the division bench order that they are hereditary
No,
heir.
my lord, no, nowhere it is stated that he is the hereditary archaka. If he is
And
an.
if the,
If,
if the,
please.
May make one
But,
submission. My lord, now, my lord, the main
you
pujari,
told me that his health condition or whatever is not correct. Where do I get that?
my lord, in the inquiry held before the Tahsildar, my lord, have specifically mentioned, and my lord, I request my lord to refer the, my lord, the Ramesh Appa before the medical board.
No. So referring someone to medical board without rhyme and reason is not correct. But where is the finding in this that he is not
11
healthy?
11 ಅಲ್ಲಿ findings
Page number
ಕೊಟ್ಟಿದ್ದಾರೆ.
11. Page number 11.
Second ಪ್ಯಾರಾದಲ್ಲಿ from the middle portion ಮೇಲೆ ಕರಗದ ಪೂರ್ವ ತಯಾರಿಯಲ್ಲಿ ತೊಡಗಿಸಿಕೊಳ್ಳದೆ ಇರುವುದರಿಂದ ಈ ಹಿಂದೆ ಕರಗ ಹೊರಲು 2016 ಮತ್ತು 18 ಆದೇಶಿಸಿದ್ದು ಕರಗವನ್ನು ಯಶಸ್ವಿಯಾಗಿ ಪೂರ್ಣಗೊಳಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು ಜನಮನ್ನಣೆ
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ನಂದೀಶ್?
11 ಪೇಜ್ ನಂಬರ್ 11 ಮೈ ಲಾರ್ಡ್.
ಏನು ಪ್ರತಿವಾದಿಗಳು ಅಲ್ಲಿ ಶುರು ಆಗಿದೆ?
ಅಲ್ಲಿಂದ ಒಂದು 10 ಲೈನ್ ಕೆಳಗಡೆ.
ಈಗ ಅರ್ಜುನ್ ಬೆನ್ ಕಾಳಪ್ಪದೇವ್ ಸೋನ್ಸು ಅಂದಾಜು 72 ವರ್ಷವಾಗಿದ್ದು ಸಾಮರ್ಥ್ಯ ಇಲ್ಲದ ಕಾರಣ ಹೊರಲು
ಶಕ್ತರಾಗಿರುವುದಿಲ್ಲ.
ಪ್ರತಿವಾದಿ ಅನುಕ್ರಮ 2 ರಮೇಶ್ ಅರ್ಜುನಪ್ಪ ಇವರು ಪ್ರಸ್ತುತ ಸರ್ಕಾರಿ ಸೇವೆಯಲ್ಲಿದ್ದು ಸಾಲಿಗೆ ಒಂದು ಪ್ರಾರಂಭವಾಗುವುದು ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಇದೇ WP ಆದೇಶದಂತೆ ರಮೇಶ್ ಬಿನ್ ಸೋನ್ಸ್ ಹೆಲ್ತ್ ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಅಲ್ಲ ಕೆಳಗಡೆ ಅಲ್ಲ ಹೆಲ್ತ್
ಬಗ್ಗೆ
ಹೆಲ್ತ್ ಅಂತ ಬಂದಿಲ್ಲ.
2016 ಮತ್ತು 18ರಲ್ಲಿ ಆದೇಶಿಸಿದ್ದು ಕರಗವನ್ನು ಯಶಸ್ವಿಯಾಗಿ ಪೂರ್ಣಗೊಳಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು ಜನಮನ್ನಣೆ ಗಳಿಸಿರುವುದಿಲ್ಲ. ಹಾಗೂ 2023 ಸಾಲ ಇವರಿಗೆ ಆದೇಶಿಸಿದ್ದು ಪ್ರಸ್ತುತ ಸಾಲಿನ ಚುನಾವಣೆ ನೀತಿ ಸಂಹಿತೆ ಉಲ್ಲಂಘನೆ ಮಾಡಿರುತ್ತಾರೆ ಮತ್ತು ಅದರಲ್ಲಿ ಆದೇಶಗಳನ್ನ ಷರತ್ತುಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿರುವುದರಿಂದ ಇವರ ಮೇಲೆ FIR ಅನ್ನು ಮೊಕದ್ದಮೆಯನ್ನು ದಾಖಲಿಸಿರುತ್ತದೆ. ಈ ಕಾರಣಗಳಿಂದ ಪ್ರತಿವಾದಿ 2 ಮತ್ತು ಸರ್ಕಾರಿ ನೌಕರರಾದ ಸರ್ಕಾರದ ಆದೇಶದ ಪಾಲನೆಯಲ್ಲಿ ಅವರು ವಿಧೇಯರಾಗಿರುವುದಿಲ್ಲ. ಅನುಶ್ರೀ ಮನೋಜ್ ಕುಮಾರ್ ಬಿನ್ ವೇಣುಗೋಪಾಲ್ ಅವರು ಅವಿವಾಹಿತರಾಗಿದ್ದು ಕರಗ ಶಂಕೋತ್ಸವ ಆಚರಣೆಯಲ್ಲಿ ಕರಗ ಹೊರುವವರು ಸಂಪ್ರದಾಯದಂತೆ ವಿವಾಹಿತರಾಗಿರಬೇಕಾಗಿರುವ ಕಾರಣ ಇವರು ಸಹ ಕರಗ ಹೊರಲು ಅನರ್ಹರಾಗಿರುತ್ತಾರೆ.
ಚಂದ್ರಪ್ಪ ರಾಜಪ್ಪ ಧರ್ಮದ ಹಿಂದಿನ 7 ವರ್ಷಗಳು ಯಶಸ್ವಿಯಾಗಿದೆ. ಮಾನವ ವಿಭಾಗೀಯ ಪೀಠದ ದೇಶದಲ್ಲಿ ಸ್ವಾಮಿ ಚಂದ್ರಪ್ಪ ಅವರಿಗೆ ಇದ್ಯಾವುದು ವಿಚ್ ಇಸ್ ದಿಸ್ ರಿಟ್
ಕೊಡ್ತೀನಿ ತಪ್ಪಾಗಿ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದ್ದಾರೆ.
2165 of 2017 ಯಾವುದು?
Kindly see the order. What the order says
I
against the interim order.
I am now for this at this juncture not worried about both of your tussle.
Yes.
I am worried about public interest. ನೀವು ತಗೊಂಡಾಗ ಯಾರನ್ನ ಬೀಳಿಸ್ಬಿಟ್ರೆ?
ಸರ್ ಇದು ಏನಿಲ್ಲ ಪೊಲಿಟಿಕಲ್ ಮೋಟಿವ್.
ಅದು ಗೊತ್ತಿಲ್ಲ.
7 ವರ್ಷದಿಂದ
that we don't know.
ನಾವು ಅಲ್ಲಿ ದೇವಸ್ಥಾನದಲ್ಲಿ ಪೂಜೆ
ಮಾಡಿ. Tahsildar has inquired everything and come to a conclusion. In public interest we will not disturb it.
My lords.
ಎಲ್ಲಿದೆ ಕೊಡಿಯೋದು?
That ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತೇನೆ.
ಮೇಡಮ್ ಅದು ಕೊಡಿ.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಮೇಲೆ ನಾವು ರಿಟ್ ಅಪೀಲ್ ಹೋಗಿದ್ದು. ಪ್ಯಾರಾ ನಂಬರ್ 4 ನೋಡಿ ಸ್ವಾಮಿ, ಪೇಜ್ ನಂಬರ್ 5.
Temporary measure without prejudice to the
rights of the contention of the parties in the writ petition. Said Chandrappa may carry on Karga for year 2017 without prejudice to the rights of against an interim order. My lords, we went in writ appeal.
That's all right.
After that, my lords, writ petition was allowed. In the same writ petition was allowed. That is, my lords, Justice Aradha's judgment. Kindly see. That is
after hearing the parties.
Yes.
My lord, one submission. What I have produced the document in that DC has recommended to remove that person from the pujari.
Which person?
Arjunappa, my lord.
Arjunappa ilwala ಈಗ?
ಇಲ್ಲ, he is also one of the applicant.
Arjunappa
will not disturb this order now. Yes.
My lord, is not disturbed. Great.
Public interest demands that. We will decide the issue later, but next time ಕರಗ ಅಷ್ಟೊತ್ತಿಗೆ annual ಇದು
ಇಲ್ಲ ವರ್ಷ
ಅಷ್ಟೊತ್ತಿಗೆ we will decide it who is to do it.
My lords, one submission. My lords, in this writ petition I sought a comprehensive prayer, issue a writ of prohibition prohibiting respondent number 4 permitting to carry on karga in the Dharmaraya Swami temple Anekal except a petitioner family members ಅಂತ ಹಾಕೊಂಡಿದ್ದೆ.
ಅಲ್ಲ ಆಯ್ತು, ಇವಾಗ ನಾವು ತಹಸೀಲ್ದಾರ್ after an inquiry has passed an order. Karga is today.
Yes. Karga ಇಲ್ಲ. Tomorrow. 12th 12ನೇ ತಾರೀಕು ಇರೋದು ಕರ್ಗ. Again they are misleading.
Ritual.
ನಾಳೆ ಫ್ಲಾಗ್ ಹಾಸ್ಟ್ ಮಾತ್ರ ಇರೋದು. ಫ್ಲಾಗ್ ಹಾಸ್ಟ್ ಅಂತ ಮಾಡ್ಬೇಕು ಅಂತಿದೆ. ನಾಳೆಗೆ ಫ್ಲಾಗ್ ಹಾಸ್ಟ್ ಮಾತ್ರ ಇರೋದು. 12ನೇ ತಾರೀಕು ಕರ್ಗ ಇರೋದು.
The person who carry karga, my lord,
5
he has to
ದಿವಸದ
follow
ಮುಂಚೆ ನಾವು
certain
ತಯಾರು ಮಾಡ್ಕೊಂಡ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ.
rituals.
ಹಾಗಾದ್ರೆ ಮಂಡ್ಯ ತೀರ್ಮಾನ ಮಾಡಿ
ಫಾಲೋ ಮಾಡ್ಬೇಕು.
My lord, they are the
ನಿಮ್ಗೆ ಕೊಟ್ಟಿದಾರಲ್ಲ ಈಗ
ಸರಿ.
ಮತ್ತೆ ಮಂಡ್ಯ ತೀರ್ಮಾನ ಮಾಡು. Yes.
And
My
so
lord,
far as my lord, for the Archaka, now the applications has been invited. 15 applicants.
I am not saying anything about the order. We'll list it on Monday at 2:30.
Great.
Yes. Tag the petition along with 23, list them both on Monday.
Great.
12th ಕರ್ಗ ಇರೋದು.
12ನೇ ತಾರೀಕು ಕರ್ಗೆ ಇದೆ.
Number 2.
For the petitioner, my lords.
ನಾನೇ ಹೇಳಿದ್ದೀನಿ. Yes.
My lords, the gist of the case is, my lords, the petitioner herein, the government of Karnataka has allotted a site to the petitioner herein, my lords. Petitioner is a married, but she don't have any children. She is issueless, my lords. The petitioner herein has gifted her property in favor of her brother, that is the husband of the respondent number 3, my lords. Husband of the respondent number 3.
If both AC and DC have held against you?
No, my lords. AC granted order in favor of us. DC has granted the said that order, my lord.
What is the order passed by DC?
ಮೇಂಟೆನೆನ್ಸ್ 10,000 rupees ಕೊಡಬೇಕು.
ಕೊಡ್ತಾ ಇಲ್ವಾ ಈಗ?
ಕೊಡಕ್ ಹೋದ್ರೆ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು. ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಆಗಿದೆ 90,000 ರೂಪಾಯಿ ತಂದು ಲಾಸ್ಟ್ ವೆಕೇಶನ್ ಕೊಡಕ್ ಹೋದಕ್ಕೆ ಈಸ್ ರೆಫ್ಯೂಸ್ ದ ಮೇಂಟೆನೆನ್ಸ್.
ಈಗ AC ಆರ್ಡರ್ ವೇರ್ ಇಸ್ ಗಿಫ್ಟ್ ಡೀಡ್ ಏನಿದೆ?
Gift deed.
ಎಲ್ಲಿದೆ ಗಿಫ್ಟ್ ಡೀಡ್ ಕಂಡೀಷನ್ ಎಲ್ಲಿದೆ?
There is no condition.
Then leave it. Yes. 10,000 rupees ತಗೊಳ್ಳಿ. ಇನ್ನು ಜಾಸ್ತಿ ಬೇಕಾದ್ರೆ ಹೇಳಿ ಕೊಡುವ.
See, without 10,000, like 10,000 she can't able to lead her life, my lord. So ನೋಡ್ಕೊಳ್ಳಿಕ್ಕೂ ಯಾರು ಇಲ್ಲ, ವಾಸ ಮಾಡಿ ಜೊತೆಲೂ ಯಾರು ಇಲ್ಲ.
ಆಯ್ತು. ಏನ್ ಗಿಫ್ಟ್ ಕೊಟ್ರದು?
ಮನೆ, my lord.
ಹೌಸ್
ಮನೆ.
ಅಲ್ಲ ಅದಲ್ದೇನೆ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಮಸ್ತಾಗಿದೆ. ಗಂಡ
ಮಸ್ತಾಗಿದೆಯಾ? ಕೊಡಿ ನೀವು.
7 ಶೆಡ್ಯೂಲ್ ಇದೆ.
ಎಷ್ಟು? We'll make it 25,000.
25,000. ವಿಡೋ ಇವ್ರು.
ಸೊ ಇದರಲ್ಲಿ
ಅಲ್ಲ ವಿಡೋ.
ಅವ್ರಿಗೂ ಕೂಡ ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ಹೋಗಿದೆ. ನಾನು ರೆಕಾರ್ಡ್ ಕೂಡ ಹಾಕಿತ್ತು, my lord. Kindly page number, my lords.
Yes.
Page number 76, my lords. 76 ಅಲ್ಲಿ schedule C.
ಈಗ now she is the third respondent is the daughter.
ಅಲ್ಲ ವೈಫ್. ಅವನು ಶ್ರೀನಿವಾಸ್ ಅಂತ ಬರ್ದಿದ್ರಲ್ಲ ಗಿಫ್ಟ್ ಡೀಡ್ ಅವ್ರ ಹೆಂಡತಿ ಇವರು.
ಆಯ್ತು. Now who is the petitioner?
ಪಿಟಿಷನರ್ ಇವ್ರ ಶ್ರೀನಿವಾಸ್ ಸಿಸ್ಟರ್.
What right do you have?
ನಾದ್ನಿ ಆಗ್ಬೇಕು.
ನಾದ್ನಿ ಮೇಲೆ ತಮ್ಮನಿಗೆ ಬರ್ಕೊಟ್ಟಿದ್ದ ಆಸ್ತಿ ಸ್ವಾಮಿ. ತಮ್ಮನಿಗೆ ಗಿಫ್ಟೆಡ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದು by bona fide belief that their families look after welfare.
Anyway, now if you want take money. Otherwise there is no condition and you have no right. We'll immediately close it. Give some money.
10,000 ಕೊಡ್ಲಿಕ್ಕೆ.
10,000 under the act. Make it a little more. We'll close it. 20.
15 ಕೊಡು. 15,000. ಯಾಕೆಂದ್ರೆ ಏನು ವರ್ಕ್ ಮಾಡಕ್ಕೆ ಏನು ಕೆಲಸ.
ಆಯ್ತು. ಏನದು?
ಅಲ್ಲಿ ರೆಂಟ್ ಕೂಡ ಬರುತ್ತೆ ಸ್ವಾಮಿ. ಅದೇ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ರೆಂಟ್ ಕೂಡ ಬರುತ್ತೆ.
Vanamala is no longer a good law. Don't tell me this. Yes. Supreme Court judgment ಬಂದ್ಮೇಲೆ ವನಮಾಲ ಎಲ್ಲ ಆಗ್ತಿದ್ದೀರಾ ನೀವು? Then.
ಸೊ ಇದರಲ್ಲಿ ಅವರಿಗೆ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಕೂಡ ಇದೆ.
The appeal before the DC was not maintainable at all.
Moreover ಅಲ್ಲಿ ಲಿಮಿಟೇಷನ್ ಇದೆ. ಲಿಮಿಟೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಮತ್ತೆ ಅಪೀಲ್ ಅಲೋ ಮಾಡಿ.
Right. Appeal before the DC was not even maintainable. Before the assistant commissioner, the petition was not maintainable because there was no challenge, no indication in the gift deed of any condition. Correct? Both of you have lost the issue. So ಅದಕ್ಕೆ ಉಳಿದಿರೋದು ದುಡ್ಡು ಅಷ್ಟೇ. 15,000 rupees will direct. ಈಗ ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ?
ಅಲ್ಲ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡಬೇಕಾಯ್ತು. 90,000 ರೂಪಾಯಿ ತಂದಿದ್ದು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು. ಈಗ ಕೊಡು ಒಂದ್ ತಿಂಗಳೊಳಗೆ ಎಲ್ಲ
15,000 ಅಂತ ಮಾಡ್ಕೊಂಡು ಅದು ಕೊಡಿ.
ಒನ್ ಮಂತ್ ಅಲ್ಲಿ ಅದರಲ್ಲಿ 4 ಪೋರ್ಷನ್ ಇದೆ. ಅಟ್ ಲೀಸ್ಟ್ 1 ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ವಾಸ ಮಾಡ್ಲಿಕ್ಕೆ ಒಂದು ಅವಕಾಶ
ವಾಸ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ.
ಈಗ
ಇರ್ತಾ ಇಲ್ಲ.
ರಿಲೇಟಿವ್ ಮನೆ 4 ದಿನ 6 ರಿಲೇಟಿವ್ 4 ದಿನ
ವಾಸ ಮಾಡಕ್ಕೆ ಕೊಟ್ಟಿಲ್ಲ.
ಇಲ್ಲ ಅವರೇ ಇರಲ್ಲ. ಬೇರೆ ಪ್ರಾಪರ್ಟಿಗಳು ಇದೆ ಅಲ್ಲ ವಿಲ್
ಈಗ ಎಲ್ಲಿ ವಾಸ ಮಾಡ್ಬೇಕು ಅವರು?
ಈಗ ಈ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿಯಲ್ಲೇ ಒಂದು 4 ಪೋರ್ಷನ್ ಇದೆ. 1 ಪೋರ್ಷನ್ ಅಲ್ಲಿ ವಾಸ ಮಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಬಿಟ್ಟು
ಈಗ ಅದು ಕೊಡಿ. She is 76 years old, sir.
Yes, ma'am.
Have some concern for that.
ನಮ್ಮನೇಲೇ ಇರ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ. ಇರ್ತಾ ಇಲ್ಲ ಅವರು.
ಯಾವ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲಿ ವಾಸ ಮಾಡಕ್ ಬಿಡಿ. ಈಗ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಇಟ್ ಆನ್ 17th. By then arrears clear ಮಾಡಿ and ವಾಸ ಮಾಡಕ್ ಬಿಡಿ. The subject petition is preferred, calling in question an orders of the assistant commissioner and the deputy commissioner. The assistant commissioner holds in favor of the present petitioner while the deputy commissioner reverses it. The appeal was in terms of the judgment of the division bench, the appeal was not maintainable before the deputy commissioner. Therefore, any order that is passed is contrary to law. Even otherwise, the perusal at the gift deed would not indicate any condition that is necessary as is enunciated by the apex court in so and so health. In that light, both the before both the fora, both the parties are not maintainable or entertainable. The issue is with regard to grant of maintenance of rupees 10,000 as is necessary under the Act. The learned counsel for the petitioner submits that the present petitioner has no roof to stay and is wandering in relative's house for shelter, and would submit that there are 4 portions in the property. 1 portion is let off to the present petitioner. It would suffice for her living, who is now 76 years old. The learned counsel for the respondent would contend that the petitioner is not coming and staying with the third respondent. Therefore, no such direction should be issued. In the light of the age of the petitioner being at 76 years, I deem it appropriate to direct the third respondent to permit the petitioner to stay in a portion of the house that she is been granted by one late G. Srinivas. Apart from the fact that the petitioner or the third petitioner would become entitled to maintenance at rupees 10,000 already agidiyalla, at rupees 15,000 per month from today. The arrears shall be calculated at rupees 10,000 from the date of the order passed by the deputy commissioner till today, and from today the petitioner would become entitled to maintenance at 15,000. List the matter on 17th in the fresh matters list. Yes, next.
3.
My lord, I'm for the petitioner. My lord, respondent bank has
Filing
issued a-
objections, my lords.
ಅವರೆಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
I'm filing objections to the petition.
Objections ಯಾವುದಕ್ಕೆ?
Main petition.
Inter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
What's the issue? Why is it in fresh matters?
My lord, the respondent bank has issued the notice demanding to pay the loan amount. The petition is ready to pay the amount, provided the respondent bank has to return back the original
I'll
documents.
say, see the objections. List the matter in preliminary hearing on 22nd. Rejoinder to the objections, if any, by the next.
Achha.
4.
Notice has been issued. Let them participate in the proceedings, your lordship.
Which proceeding?
64A proceedings. The notice, they've challenged the notice.
Status quo ಕೊಟ್ಟಿದ್ದೀನಲ್ಲಿ.
Lord, even after
So
status
we
quo,
will
my
not
lord,
disturb. Let them.
your lordship has granted status quo on 26 Malad, 26 Malad, 27 Malad, they went to spot and remove all my Malad and they will now begin the Malad this one to plant the trees Malad. ನಾವು ಕಾಂಪೌಂಡ್ ಎಲ್ಲ ಕಿತ್ತಾಕಿದ್ದಾರೆ.
ನನ್ನ photo ಕೊಡಿ.
The learned
No, I'll seek instruction. I'll find
learned
out.
counsel for the learned AGA.
This is a grant in 1959 grant sir.
One ನಿಮಿಷ. The learned AGA is directed to secure instructions as to how on the intermotor ಗೊತ್ತಿರಲ್ಲ ಅವ್ರಿಗೆ, as to how on 29/3/2025, despite the grant of an order on 27/3/2025, the state has interfered with the possession and has ಏನ್ ಕಟ್ ಮಾಡಿದಾರ ಮರಗಳನ್ನ.
ಇದು
Ask him to stop.
ಕಂಬ ಕುಚಾಕಿದ್ರು, ಕುಚಾಲ ಮುರಿದಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಕಾಂಪೌಂಡ್ ಗೋಡೆ. And ನೋಡಿ digging ಮಾಡ್ತಾ
The
ಇದ್ದಾರೆ.
state appears to have entered the land of the petitioner and used a JCB to level the land, the AGA shall secure instructions, and if, despite the knowledge of the interim order, such steps have been taken, the matter would be viewed seriously. List the matter on 16th in the fresh matters.
Application, my lord, LR applications to be allowed.
ಯಾವ ಎಲ್ಲಾರ್ application?
Sir, a photo could you?
Cities are dead, my lord.
Sir, a photograph.
IA1 is for the reasons indicated,
Photograph
so
could
and
you
so
note
allowed.
What do you will set?
Next.
Five.
Parole, your lordship. Three not,
302?
302 and 397, my lord.
12 years and 11 is in
ಎಷ್ಟನೇ parole?
ninth
This is a
parole.
ninth parole, my lord. It's already completed 12 years, 11 months.
When did you come back for the last parole?
20. He had filed an application on 28/11/2023, which was rejected.
23 is rejected. ಆಮೇಲಿಂದ ಕೊಟ್ಟಿಲ್ವಾ? The petitioner is before this court seeking the following prayer. The petitioner gets embroiled in a crime number 102 of 2010 on a crime being registered on 17/6/2010. Since then, the petitioner is said to be in prison The petitioner gets convicted of the offences punishable under section 302, 392 and 397 of the IPC. The issue in the list does not concern the IPC, sir. The petitioner, who is the convict, yours, Nivena,
Yes, my lord, petition itself.
the petitioner convict has availed parole on 9 occasions, and the last of the parole that he availed was in the year 2023. An application comes to be filed by the petitioner. Again, madilva?
Illa 23 ne last.
26,
So it comes to be rejected in the year 2023 itself. Now, the present petition is preferred, seeking parole and challenging the endorsement dated 26/12/2023. In the normal circumstance, the petition would not be entertained, but showing lenience to the petitioner, as the challenge is for an order of challenge is to an order which is 2 years old, and no application after the said order is submitted by the petitioner. Notwithstanding the same, I deem it appropriate to grant parole to the petitioner for a period of 60 days to become operational from Monday.
My lord, liberty maybe.
60 ಮೇಲೆ liberty na?
90
Yes.
days, for 9 times he has come out.
60.
It's almost
Already
every
completed
year.
15 with, along with remission, my lord, 15 years, 7
Yes.
months.
Next 60 days haki.
Much okay.
First of all, application ಕೊಟ್ಟಿಲ್ಲ, I should have dismissed it right away. 2 ವರ್ಷದ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ಈಗ ಮತ್ತೆ ಎಲ್ಲಿದೆ ಅಪ್ಲಿಕೇಶನ್ ಆಮೇಲೆ ಮತ್ತೆ?
Lordships directed me to file affidavit.
What
With
affidavit?
regard to negotiation.
Ah.
I have.
We close it on the affidavit?
Document number 3, your
It
lordship.
be, my lord, treated as an exception,
You're correct, yes.
one-off case. My lord.
The petitioner is before this court seeking the following prayer. Heard so and so. A notice inviting tender comes to be issued on 25/6/2024, which was to be operational for a period of 1 year for supply of ready meals, fresh and first quality to the General Hospital at Sirsi. In terms of the Transparency Act. The petitioner emerges successful in the said tender. The price was not acceptable to the respondent state, and therefore ಹೊಸದ್ ಮಾಡಿದ್ರೆ tender, fresh tender,
It's not a fresh tender.
and therefore the work order was not issued to the petitioner. The learned counsel for the petitioner instructions submitted that he would match the price that the state is wanting, and therefore this court directed the petitioner to sit across with the state and settle the dispute with regard to, as the dispute was concerning only the financials. The order dated 18/3/2025 reads as follows. The petitioner was further directed to file an affidavit of undertaking with regard to the price that he has quoted in the negotiation. The affidavit is also filed before the court. In the light of the aforesaid circumstance, as this emerged to be a one-off situation and as a one-off solution, the affidavit is accepted and a direction is issued to the state to issue the work order in favor of the petitioner strictly in consonance with the prices that is indicated in the affidavit of undertaking by the petitioner. The work order shall be issued in the next 1 week.
Work order is supposed to expire in the next, I mean, the term of the tender expires for the next 3 months.
So. Work order shall be issued in the next 1 week. The learned HCGP would submit that the term of the tender was only for 1 year. 1 year which would expire by the end of July 2025. The petitioner, though has emerged successful, has not been in a position to enjoy the fruits of such success, as no work order was issued owing to certain dispute with regard to the financial price that he had quoted. If that be so, and the petitioner and the state were in a dialogue, it cannot be said that the petitioner would be awarded the contract only for a period of 3 months. Therefore, the period of contract shall commence from the date on which is awarded and would be in operation for a period of 1 year. Just 1 year another.
6 months, my lord.
Because
we'll have to recall another tender.
1 year on 20 in for
ಈಗ ನೀವು
paragraph
ವರ್ಕ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ರೆ ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ರಿ?
1 year.
1 year.
For a period of 1 year
Deposited
from the date of such issuance. In the light of this solution being stuck as a one-off solution, the petitioner shall not draw any right from this order to negotiate future terms or claim future right in any tender that is issued. Yes.
This may not be treated as a precedent.
One-off, what is this? Yes.
My lord.
Next installment.
My lord, he has complied with the interim order. He has complied with the interim order.
Complied.
Sale has not taken place.
Not taken place.
For some more time, my lord.
ಮತ್ತೆ ಸೇಲ್ ಯಾವಾಗ ಇಶ್ಯೂ ಮಾಡ್ತೀರಾ?
Now there is an interim order, my lord. After, if he pays
more time, my lord, I deposit some more amount. Pay for some more.
ಸೇಲ್ ಆಗಿಲ್ವಲ್ಲ ಈಗ? The petitioner is before this court seeking the following prayer. This court on 10/3/2020, on 27/1/2025 had passed the following order. Recording the compliance of the interim order, this court on 10/3/2025 had passed the following order. The learned counsel for the respondent now submits the sale on the intended date did not take place. Therefore, the date of auction has spent itself. In that light, the petition is disposed as having become infructuous. The learned counsel for the petitioner submits that the interim order has been complied with by making certain deposit. In that light, in the event the bank would issue another sale notice, the amount that is deposited pursuant to the interim order shall be taken note of. Yes, with the aforesaid observation, the petition stands disposed. Next.
8.
Petitioner, Lord, I complied the interim order, Lord. Entire 20 lakhs is paid.
ಯಾವಾಗ?
Lord, on 29/3, we have paid 4 lakhs. On 1/4/2024, on 2/4, we have paid 2 lakhs. So total 20 lakhs we have paid, my lord.
The learned counsel for the petitioner submits that pursuant to the interim order, 20 lakhs has been paid to the bank.
Balance was 36 lakhs 18,000.
ಅದಾದ್ಮೇಲೆ
Let them regularize, my lord.
ಎಲ್ಲ ಈಗಲೇ ತಗೊಂಡ್ಬಿಡ್ಬೇಡಿ. Petition ಹಾಕದ್ಮೇಲೆ ಹೇಳಿ. 20 lakhs has been paid to the bank. The learned counsel for the respondent acknowledges such receipt. ಏನಾಗ್ಬೇಕು ಈಗ?
Another 10 lakhs. Another 16 lakhs is there, not?
Another
16 lakhs, my lord. Regularize, let them regularize, my lord. I'll pay by installment.
16 lakhs ತಗೊಡಿ.
Let them regularize, I'll pay by installment, my lord.
ನೀವು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೊಡೋದಾದ್ರೆ ಅವರು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ತಾರೆ. ಒಂದೇ ಸರಿ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಒಂದೇ ಸರಿ ಕೊಡಿ.
In July, I will approach them for OTS facility, my lord. Let them not take any.
In the interim, the order may be passed for another 10 lakhs or 15 lakhs, so that.
List the matter in the first week of June 2025, 6th of June 2025. The 5th of June 2025, the interim order stands extended subject to the condition that the petitioner would deposit another 10 lakhs by the next date.
my lord, I'll get money only in the month of June, my lord. It's a school. I'm
June ಗೆ
running a
ಹಾಕಿರೋದು
school.
ಈಗ.
ಅಲ್ಲ ಅವಾಗ ಇನ್ನು ಸ್ಟಾರ್ಟ್ ಆಗಿರುತ್ತೆ ಅಡ್ಮಿಷನ್ 5th June ಬೇಡ
May ನಲ್ಲೇ
15th
ತುಂಬಿಸ್ಕೊ-
ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ,
ನೀವು ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್.
Yes,
ಎಸ್.
From May only the admission fee will be taken from all the students.
ಅಲ್ಲ 15th ಹಾಕೊಂಡ್ರೆ I'll pay, my lord. 15th I'll pay.
June 15th.
June 15th.
ಹಂಗಾರೆ 15 lakhs.
ಅಲ್ಲ
15 lakhs.
ಇರೋದೇ 16 lakhs ಇದೆ. June 15th.
ಇಲ್ಲ ಇಲ್ಲ 16 lakhs ಇಲ್ಲ ಸ್ವಾಮಿ. 24 lakhs ಇದೆ.
Let the order remain. Yes, next.
Number 9.
For the petitioner. Information and state.
Your Lordships, on the last occasion, I directed my lords to file the affidavit which we have filed before the Supreme Court.
Same has been filed.
The matter is pending before the apex court.
Yes, sir.
Please, my lords, please, my lords.
We'll take it later.
Yes, sir.
First week June.
Yes, sir.
Yes. This court on 5/3/2025 had passed the following order. The position remains the same even today. Therefore, list the matter in the third week of June 2025. Heard so and so, the senior counsel. Yes.
Copy of the affidavit
I will
filed.
serve the copy.
ಯಾವ ಏನ್ affidavit?
Affidavit. There was a direction by this court
There
that
was
the
a-
affidavit that the state filed before the.
Whatever
Supreme Court.
affidavit is filed,
Before
the
the
copy may be
ನಾನ್
furnished.
ಮಾಡಿದ್ದು.
ಇಲ್ಲ previous.
The coordinate benches.
ಹೌದು ತಾವೇ ಮಾಡಿದ್ದೀರಿ.
ತಾವು ಮಾಡಿದ್ರು last date.
Last
5/3
5/3
ಗೆ.
5/3 ನಲ್ಲಿ ತಾವೊಂದು.
No, earlier ಆ direction ಇತ್ತು,
ಹಾಗಿತ್ತು,
ಅದನ್ನ
that-
ನಾನು
yes,
reiterate
yes,
ಮಾಡಿದೆ. Just ದೇವದಾಸ್ ಅವ್ರ order.
Yeah, on 31st we have filed it, my lord. I will give.
The
a copy.
learned AGA, special counsel.
ಇಲ್ಲ. Yeah, I am appearing for the CIC, R3.
The learned
And
senior
other-
counsel, learned AGA for the state, learned AGA would submit that the order dated 24/2/2025 as observed on 5/3/2025 has been complied with and the affidavit is placed, affidavit is filed before the court. Same is taken, ಹಾಕಿದಿರಲ್ಲ?
Learned AG is also on the.
Please,
Same
my
as
lords.
it's called,
Please,
heard AG ಅಂತಾನು ಹಾಕ್ಬಿಡಿ.
It's filed on 21st of March, my lords.
So, yes,
Copy.
yes.
Lord, I appear for the petitioner. The case, my lord, of lease rental discounting.
Huh?
Lease rental discounting, entire amount has been repaid. The issue is only with respect to prepayment charges.
There is a condition, my lord, in the,
What conditions?
in the sanction letter, my lord. Kindly turn to page 39, my lord.
37.
Clause.
37.
39, my lord. Prepayment charges. 2% plus GST.
Where is it?
It is in the
37.
third, fourth column, my lord. Page 39 of my objections, my lord.
Objections.
Objections. The same thing. At page 37 of the petition, my lord. The same document is at
Yeah,
page
lord.
37. Same thing have been produced. Everything depends on an interpretation of that clause 2, my lord. Interest reset. Prepayment is 2% plus GST. Then point 2, if interest on the reset date, that is every year, is not acceptable to the borrower, borrower would have the option to prepay the outstanding facility owing to such lender within the next 3 months from such
Oh,
date.
the
of
answer,
spread.
where are you reading?
I'm sorry, prepayment charges in the middle. Page
I'm at
37.
page 37.
37.
Prepayment charges, all right.
Yes, 2% plus GST. As per extant guidelines of service charges as per circular number so and so, no prepayment penalty would be able to lender. If one, prepayment is made at the instance of lenders, that is not the case. 2, if interest on the reset date or repricing date is not acceptable to the borrower, borrower would have the option to prepay the outstanding facility owing to such lender within the next 3 months from such date of spread reset or receipt of advice from the lender by giving a notice of 30 days. Therefore, my lord, we made a request in November saying, please tell us the reset interest rate.
All right.
They don't tell us. Finally, they inform us, my lord, in January. We say, please treat this as a notice. We do not want this reset. We are therefore paying the entire amount of money. So the entire amount of money was paid by us.
So you have pre-closed everything.
Pre-close everythth. We are not agreeable to, my lord, the interest on the reset date. And that is the clause. Therefore, my lord, we said, then they said, no, you have to pay 3 crores as
Pre-closure.
Pre-closure.
My lord.
Annexure, page 55, my lord.
Hmm. 3 crore 25 lakhs.
3 crores, 3 lakhs, 15,000 plus an annual review charges of about 5 lakhs 90,000. Totally, they say, but we paid every single rupee with interest till the last date. They have received the entire amount of money. Now they say this clause, according to this clause, you have to pay.
So have you accepted this clause?
This clause, whatever is in the sanction letter, my lord, there is no difference.
Not only that, my lord, kindly turn to page number 48 of my objections, my lord. 48, my lord. Clause 9. In the event of prepayment of loan by the borrower before the stipulated repayment schedule, the bank is entitled to levy a prepayment charges of 2% or such rates on the applicable drawing limit or on the balance outstanding, whichever is higher.
Generally, in any banking transaction, there would be prepayment. If you want to pre-close it, it would be charged.
It would be charged. But there is a condition super added here that it will be charged if, my lord, if in the entire year, every year there is a reset period. Reset period, my lord, will find at page 32. Interest reset is annual.
Correct. Oh, the interest reset is annual.
Therefore, my lord, I have an option at that point in time to say I don't want to continue with this if I get a better rate somewhere else. Therefore,
now you borrowed it from somewhere else and cleared the loan here.
no, my lord, I have shifted the loan to some. Yes, yes.
All right.
Yes, my lord, I
Yes.
borrowed from somewhere else. I've told them also that I have other options. But my obligation to pay prepayment is only if the interest reset is not acceptable to me. And that is an option given to me.
No, would that wash away the 2% charge
Because
also?
please see the language. As per extant guidelines of
No,
service.
no, I am at clause 9. You're referring to language in clause 9 or what?
No, my lord, I'm referring to the sanction itself, which sanction is not what is binding between the parties at page 31.
What is this he is referring to?
Agreement, my lord.
This is the agreement signed afterwards.
Anyway, you signed this agreement also.
The agreement is also signed, no
Yes.
difficulty there. But the point, my lord, is the conditions are contained in the sanction letter. Because the three conditions are, prepayment is made at the instance of lenders. If they ask me to prepay, then I can't ask for prepayment penalty. Second is, if interest on the reset date, this is an independent clause. If interest on the reset date or repricing date is not acceptable to the borrower, borrower would have the option to prepay the outstanding facility owing to such lender within the next 3 months from such date or spread reset or receipt of advice from the lenders by giving a notice of 30 days. So it's very clearly specified, and that is the condition on which I agreed to these prepayment charges, that I will make payment of this prepayment charges only in the event, and I can only do it at one specific point in time. Throughout the entire year, you cannot.
But there is an agreement signed by you.
Yes, but that agreement is there.
How can this override the agreement then?
But this
is a sanction letter.
There are two things, my lord. The sanction letter ultimately governs the mechanism by which I have been sanctioned this loan.
Correct.
And I have accepted it on that basis.
Correct. Pursuant to that, you sign an agreement saying pre-closure charges will be 2%.
Correct. It is also 2% here as well. Therefore, you will have to read both. It has to be read both, my lord, because there are three conditions here, which is not there in the agreement otherwise. It can't be that the agreement overrides this.
No, I don't think either would override.
Therefore, my lord, if it all has to be read together.
My lord, I am relying on one of the judgment, 2024.
Pre-closure charges, yes, you have to pay. Other incidentals are ಹೇಳಿದ್ರೆ that will interfere.
But if there are certain conditions.
Paragraph.
My lord. Paragraph 21, my lord. That apart to take the benefit of section 74 of Indian contract, the onus is of the petitioner to show that.
No, the answer. It is. It's common knowledge that.
No, prepayment is common knowledge, but if there are conditions attached to the prepayment, and it is said that this is the mechanism by which prepayment charges will apply, then I am entitled to enforce that condition.
We'll see. A little difficult to accept.
No, the whole reason is these are all floating rates of interest. They're not fixed
Correct.
rates.
No problem at all. Floating rates of interest. You sanction letter is there. Pursuant to the sanction letter, you have signed an agreement which agreement says 2% pre-closure charges. 2% pre-closure charges in every time. Because you see, if the loan is spread out, they would get some amount as interest. They are losing that by pre-closure. For what is the compensation for that loss is 2% at least. That's what I.
Normally, yes, no. Without question, in a normal scenario, that would be the case where I must pay.
Apart from that 2%, have they charged anything?
Then there is another 9 lakhs which they've charged.
9 lakhs is that they should have closed before 30/12/2024, my lord.
That is
they have closed it on 1/2/2025. So next.
How will I close?
One day.
Not one day. 1 month. After 1 month,
but,
30/12/2024, they were supposed to clear it.
How do I clear it before you give me the interest reset? Interest reset. You
That
give
is
me
also
January.
mentioned in the
In
sanction letter, my
January.
lord, 60 rupees per
Can
lakh.
documents ಕೊಟ್ಟಿಲ್ವಾ?
These are documents now, my lord, by virtue of an interim order, we've given a bank guarantee. And then on the basis of the bank guarantee, my lord, this has been returned to us.
And then we'll hear it. Heard the learned senior counsel John Chinnappa and the respondent bank. List the matter in preliminary hearing in B group on 23rd. Yes, next. But prima facie
Yes,
difficult.
I understand. I also check, my lord, if there's something which will support us.
Comply ಮಾಡಿದ್ದೀರಾ?
Yeah, complaint.
The interim order stands complied. Post the matter in B group on 24th.
Further conditions, because only 10% was ordered.
ಎಷ್ಟಿದೆ?
It's around 50 plus 50 lakh,
50 lakhs.
50 lakhs plus expenses and charges.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. Another 5 lakhs you pay.
It's a guarantor petition, my lord.
We'll grant you 4 weeks time.
8 weeks time, my lord.
I will do it like this. List the matter on 6th June. 10% more shall be paid. The interim order stands extended till the next date of hearing, subject to the condition that the petitioner would deposit another 10% to the bank. Yes. On or before 6th June. Huh? List on 6/6.
In this case, entire money has been paid by the auction purchaser.
Sale certificate is issued, my lord.
ಕೊಟ್ಟಿದ್ದೀವಿ.
I've also paid the TDS amount, my lord. I'll just
I
produce
filed the
proof for that.
application for amendment of pleading additional grounds as well as the relief was even with regard to quashing of the
Let them
sale
go to the
certificate
DRT
also. Millard, application may be allowed. And the impleading applicant, Millard, who is subject to the result of the petition, he has, during the pendency of the petition, Millard, the sale has
Petition
taken
itself
place.
becomes infructuous now, my lord. Everything is done. I've already finished everything, paid the TDS amount also. All that remains is now the registration, my lord. Registration, my lord, 1.25 crores is the stamp duty. That's my only, if the petition is disposed of, because, my lord, he's challenged the sale auction notice. Now, my lord, sale certificate was issued on 19/3/2025 itself. I paid the entire amount. TDS is paid.
During the pendency of the writ petition ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಯಾವ್ದದು? Which writ petition?
During the pendency of this
Sale
writ
ಆಗಿದ್ದು
petition,
ಯಾವಾಗ?
sale, during the pendency of the writ petition.
Sale
7/3,
ಆಗಿದ್ದು.
7/3. They have taken
Lord, in
notice
this
on
matter, my
5/3.
lord,
So 5/3 the petition is preferred.
Yes, 6/3 they have taken notice, the
But since-
bank has taken notice.
If my lords has my impeding application, my lord, I produce the sale certificate in that.
in this case, my lord, since the stay has not been granted, my lord,
ಏನ್
because
ಮನೇನಾ ಇದು?
illa commercial complex, this is the 7th writ petitions, my lord, in this matter. And we opposed
Come on record.
granting
I'll
this
come on
stay.
record, but my lord, only issue here is, my lord, because of the pendency of the writ petition, registration now, my lord, is becoming a problem. Let him go to DRT, my lord. I'll also go, I'll impede myself before DRT, because this is a 7th
Oh,
petition.
which is the first writ petition?
My lord, the first writ petition, I have filed my synopsis, my lord, dates and events.
Millard,
Sorry, I'll do.
Millard, 2 writ petitions are pending.
ಒಂದ್ ನಿಮಿಷ.
Dates and events, Nana. Dates and events, my lord.
ಎಲ್ಲಿದೆ dates and events?
My lord, we filed, my lord, on 7/3/2025 itself we filed. But, ಅದು ಮೇಲಿಂದ.
It may be heard, a date may be fixed, it may be heard. I will be in a position to.
I am not, dependency of this will not come in the way of anybody's right being taken away. Yes. Otherwise you go
My
before
lord,
the
in this
DRT.
case, my lord,
Which is, ಎಲ್ಲಿ dates and events ಕೊಡಿ ಸರ್.
madam, ಇದು
May I just.
ಯಾವ ಫೈಲ್ ಮಾಡತ್ತೀರಾ ಗೊತ್ತೇ ಇರಲ್ಲ.
7/3/2025.
ಫಸ್ಟ್ ರಿಟ್ ಪೆಟಿಷನ್ ಯಾವುದು? 216200 of 23.
Yes,
ಅದು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
closed. 13/2 has been challenged earlier, my lord.
ಆಯ್ತು. Order to regularize the account. ಆಮೇಲೆ
Petitions are pending, Millard.
ರಿಟ್ ಪೆಟಿಷನ್ stating the violation agreed to pay the loan. Refuse also. Loan was declared as NPA. Yes, you file whatever amendment you want.
Please, Millard.
The amendment now they seek, my lord, is to say that the valuation was not proper. My lord, I have paid 6.5 crores more than the base
My lord,
price
in this
itself.
case, my lord, para 15, they themselves have admitted, sir, the value of the property is 20 crores. Their petitions kindly see, my lord, para 50. And my lord, we sold it for 20
Will
lakhs.
not spend time on the person who has lost all his right.
Millard.
And
Sale certificate, ಸೇಲ್
Sale
ಸರ್ಟಿಫಿಕೇಟ್ ರಿಜಿಸ್ಟರ್
Right,
ಆದ್ಮೇಲೆ
Millard, the building, Millard, even as per I have produced the valuation certificate also. They have also produced this valuation certificate. The valuation certificate, Millard, their valuation certificate speaks of an area of 13,900 square feet. The mortgage property is 24,000 and dot. 11,000 there is a shortage.
They themselves.
11,000.
Wait,
Yes,
sir.
one minute. I have produced an valuation certificate of the Union Bank 1 year prior to that, wherein the valuation then made itself is 20 lakhs. Here the reserve price.
1 minute, ಎಷ್ಟನೇ ಸೇಲ್ ಇದು?
For me, the
Was the first sale.
ಆಯ್ತು, ಎರಡನೇ ಸೇಲ್.
first sale, my lord, they have taken.
That's all right, ಎರಡನೇ ಸೇಲ್ ಅಷ್ಟೇ.
ಎರಡನೇ sale, my lord, they are telling that the value of the property is 20 crores. We sold it 20 crores, 12
First
lakhs.
sale only 24/1/2020. Same sale certificate, my lord. I request your lordship.
Well, let him amend this. You also come on record.
Please, my lord, but then the only issue here is, my lord,
Don't worry,
1.25
sale
crores.
certificate is already there in your favor.
Short
But
date may be
there's a
given,
sale
no
certificate.
problem.
Yes. The counsel Siddharth Suman has filed an application seeking his impleadment into these proceedings. The learned counsel would submit that pursuant to the sale during the pending, pursuant to the sale which was held on 7/3/2025, the sale is confirmed in favor of the auction purchaser and the sale certificate is also issued in favor of the auction purchaser. And the auction purchaser has paid the entire amount of
20 crores, 12 lakhs, 50,000.
20 crores, 12 lakh, 15,000. 50,000. All that remains is registration of the sale certificate before the jurisdictional sub-registrar. The learned counsel for the petitioner would, the learned counsel for the bank would submit that this is the 7th round of litigation, if not 7th writ petition filed by the petitioner at every point in time, and all of them have been turned down or pending at some stage where no protective orders are granted. Even in the case at hand, there are no protective orders granted. The learned counsel Siddharth Suman submits that the remedy to the petitioner would not be before this court, but before the DRT to raise a challenge to whatever has happened in the light of the judgment of the apex court in the case of Bafna versus so and so.
And subsequently Sanjay Sharma versus.
Sanjay Sharma, yes, both Bafna and Sanjay Sharma. ಮೊನ್ನೆ ರಿಲೇ ಆಗಿದೆ. So therefore, the learned counsel would now submit that the valuation that was secured was erroneous and therefore the matter has to be heard. And has filed an amendment application. The application for amendment would be considered along with the main matter. The impleading application stands allowed and the respondent, the petitioner shall amend the cost title. It is made clear pendency of this petition will not come in the way of anybody's right being exercised, much less the right of the auction purchaser. Yes.
Please.
Another judgments of this court, my lord, 2012.
ಇದರಲ್ಲಿ
valuation ಕೂಡ.
Yes. ನೋಡೋಣ. List the matter after 2 weeks.
Please.
Next.
Publish.
For the respondents and for the petitioner in this case.
Today I have received the statement of objections.
My objections are ready.
File ಮಾಡಿ.
Monday, your lordship may have it in the fresh matters.
Why fresh matters?
The stay is operating.
The show cause notice is only for the willful defaulter, my lords. And the show cause notice.
Test the matter on 15th in the fresh matters list. Interim order subsisting will continue till the next date of year. Next. Police protection.
Your lordship, we had placed the report in a sealed cover.
Oh, that report is with the threat analysis.
Threat analysis.
Oh, the report is in the chamber. We'll take it tomorrow then. Yes, yes. List tomorrow. Next.
Lordship, this matter is one where the conflict of jurisdiction is in question. There is a civil court that has protected us, but then there is the IB court, which is also conducting the liquidation proceedings. So in this connection, this question of law arises. Page 480, your lordship, the petitioners are all individuals.
But shall I make one request?
No, it can't be heard at this stage here. We'll give a date and hear it.
The liquidation today is a meeting which we suspect will lead to
various irreversible consequences.
How is the writ maintainable against
Yes,
that?
that's
Yes, the writ is maintainable for two reasons. I already have an order against the SBI against using the foundational record, page 480, may kindly be seen, Your Worship. That is a 1-year-old order. SBI enters appearance, file their written statement, but do not ask for vacating of the order because they obviously know.
Which
Page-
is this, one minute, one. There are other SBI matters pending on same property?
Malad,
The IRP,
same, Malad.
same.
And
Malad, what happened was, this company has already been ordered to be wound up. Now, Malad, before winding up itself, they have given an undertaking before the Honorable Supreme Court that they will clear the entire loan.
it's not.
Then they filed, then
Not
they
an
filed
undertaking.
We'll fix a date. for
And there will be irreversible consequences.
What irreversible consequence?
The liquidation has been ordered, and incidentally, the same IRP has also been appointed as the official liquidator, which we understand Your Lordship is already dealing in a batch of
Yes,
matters.
I
So it's the
remember.
same IRP, respondent number 4. So this matter raises this question, when I have a civil court
We'll
remedy,
take it on Monday. Yes. 7th.
yes, an interim order, some
No,
interim
I'm
order,
not, I'm
protective
opposing
order,
for any.
no
interim order
coercive
for this
action
reason,
against
Malad.
us.
Your Lordship may kindly see, he has filed a suit, Malad. These are all unnecessary, Malad, approaching this court and civil court, NCLT, NCLAT, Supreme Court, Malad, all these, Malad, number of cases are pending now. Now, Malad, his main contention here is no proceeding should go on.
That
Please see
is not the
Malad, whether
contention. That
writ
is
of
not the
mandamus is
contention.
maintainable is the first
So-
question.
So the question
First,
really,
Malad,
We'll decide that on Monday, whether it is
Your Lordship
maintainable or
kindly
not
have-
at the threshold, and then continue hearing of the matter.
Your Lordship
so
kindly
no
have-
coercive action until then, because we have seen a spate of coercive actions they have
Malad,
taken in the
there is-
past.
The company has already been wound up. What is there, Malad? Now the professional, it is not in my hand.
Monday ವರ್ಗೆ ಏನಾಗುತ್ತೆ?
Huh?
Monday ವರ್ಗೆ
ಅಲ್ಲ,
ಏನಾಗುತ್ತೆ?
no precipitate action. Then what is that action they have to?
There is a meeting today,
Malad,
and the
now-
meeting will in fact lead to orders to
Absolutely,
publish for auction and all of that. So everything would be irreversible. And Your Lordship may kindly note, Article 21 gives us the right to a judicial remedy. And if a document is forged or not is a matter that the IBC does not allow NCLT to determine. That's been the consistent position of the NCLAT, of the Supreme Court, of the High Courts.
We'll decide about it.
So I would be deprived of a constitutional remedy. Now I have a trial court. Now they come here and say there is no merit, but they did not get the
No, no.
order vacated
First-
in the last
first-
1 year.
First, you have to satisfy on maintainability,
Yes,
then on
yes,
merits.
yes,
Prima facie,
Yes.
I do not find entertainability of the petition.
yes, Your Lord.
We'll see.
Certainly. So it's our burden to take the court
that's
through the bare threshold facts,
And not. and-
undisputed facts to
and
show
true,
that, yes,
Not facts at all.
yes, Your Lord. Even on law, just on law.
On law, you'll have to tell and not go on submitting till the cows come back.
No.
but,
I barely may
Nice.
take a few 10,
Yes,
20 minutes just to
that's
show
all.
on the question of law. Now, because the IBC does not vest the NCLT with the jurisdiction to determine if the foundational document is forged, courts have said my only remedy is in a civil court, which I have invoked. And the civil court passed a restraining order against SBI 1 year ago. And they do not get that vacated. They go to the court, they file the written statement. Now they come to this honorable court and say that trial court order doesn't mean anything. Now that is certainly not a position they can take because the IBC does not give them that authority.
We'll,
We
let's
filed,
let's
the
sit on
application.
Monday at 3:30.
Grateful. And
Yes.
no precipitate.
Tuesday.
ಯಾಕೆ ಮಂಡೇ ಇರಲ್ಲ?
Partner matter.
ಆಯ್ತು, Tuesday. List the matter on Tuesday at 3:30. The respondents, the apprehension of the petitioner is that till the next date of, by the next date of hearing, coercive steps would be taken which would be detrimental to the interests of the petitioners. He would submit that they are irreversible. The learned senior counsel G. Krishnamurthy, representing the respondent, submits that the petition itself is not maintainable. Therefore, is neither maintainable nor entertainable. Therefore, to decide on the entertainability or otherwise of the petition, list the matter on Tuesday at 3:30 p.m. It is made clear the court would hear the threshold bar, i.e. entertainability of the petition, and then on its merit.
In the interim.
In the interregnum, no coercive steps will be taken.
Well, let him say what is the coercive steps. I do not know.
It's
What is
important to know
nothing
before
has
the
been-
court
one
could
minute.
issue notice they have come. Now, is this the only
1
matter
minute.
SBI is
Notice
handling?
agilva inni.
Illa, they came
ನಾನು
before the
ಈ-
notice was formally issued. So that probably might alert this honorable
1
court.
minute. Therefore, till the next date, coercive steps of any kind that would ensue or frustrate the proceedings before this court shall not be taken.
Grateful.
Yes.
The first question is,
ಅಲ್ಲಿ
within 7 days, what you have, once the,
ಆಯ್ತು ಈಗ ಏನಾಗಲ್ಲ.
once the,
ಒಂದ್ ನಿಮಿಷ.
question is this.
2018 proceedings.
One minute.
There is.
Now, sir, you are saying nothing is going to happen.
No, there is.
ಒಂದ್ ನಿಮಿಷ ನೀವೇ ಹೇಳಿತ್ತಾನೆ ಏನಾಗಲ್ಲ ಅಂತ.
ಅಲ್ಲ ಮೇಡಮ್, the question is.
ಇಲ್ಲ ಏನಾಗಲ್ಲ ಅಂತ
correct.
ಹೇಳಿದ್ದು.
ಒಂದೇ ಒಂದು ನಿಮಿಷ.
ಹಾಗಾದ್ರೆ ಏನಾದ್ರು ಆಗುತ್ತೆ ಅಂತ ಕರೆಕ್ಟ್.
ಇಲ್ಲ ಏನಾಗೋದಿಲ್ಲ, ಯಾಕಂದ್ರೆ what
ಏನಾಗೋದಿಲ್ಲ ಅಲ್ಲ, worry about the order.
what happened is,
See, if there is,
injunction
if this order is not going to affect anybody, why worry?
Allah, we are conducting a meeting for that. What is the difficulty for them is the question.
Auction. The decision on
I have
auction will be
said-
taken there.
I
You will have
have
to
said-
publicize it.
No coercive steps of any kind shall be taken against these petitioners. If no steps are being taken, leave it. ಅದರಿಂದ ಏನಾಗಲ್ಲ, ಅವ್ರಿಗೂ ಏನು ಉಪಯೋಗ ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮಗೂ ಏನು ಉಪಯೋಗ ಇಲ್ಲ ಅಂದ್ರೆ ಇರ್ಲಿ ಬಿಡಿ. ಇನಾಕ್ಯಸ್ ಆರ್ಡರ್.
Meeting ಮಾಡೋದಕ್ಕೆ ಅವ್ರದ್ದು ಏನು ಮತ್ತೆ his contention is.
This is a 7-year-old proceeding. This would be the first instance where the court is passing such an order. No court passed any order restraining this proceeding for the last 7 years.
Which
This is a proceeding that actually they initiated in 2018. So this is a 7-year-old proceeding, and they should not really worry about 3 days in a 7-year-old proceeding where no such order has been passed so far.
All right.
Grateful.
Tuesday. ಏನಾಯ್ತು? ಶಾಂತಿಭೂಷಣ್ ಸರ್ ಅವರೇನೋ
Endorsement.
We have intimated them a lot with regard to the time. I
As
myself.
per the prayer, they have intimated.
ಅಷ್ಟೇ
We incorporate.
ಆಯ್ತು ಅಷ್ಟೇ ತಾನೆ.
That's all.
ಅದಕ್ಕೆ ask them to get you.
Yesterday I have sent a mail on.
He will do it, sir, don't worry. Yes.
Endorsement annexer N, page number 39.
Who is he? Why do you get the clients and come?
They are voluntarily.
Huh?
Voluntarily, yes.
Yes. Will refuse interim orders now.
Annexer N, page number 39, endorsement. Rejected on the ground that he is not a resident of Mysore. But in fact, he enrolled, after enrollment, he is practicing and
Learned counsel C. Jagadish is directed, Nivena.
Last
Backward
time-
class,
last-
Nive.
last Backward
class. Learned HCGP is directed to accept notice for the respondents. Copy there.
Copy there. If I could just
Update
make
of
one
hearing.
submission on it. He doesn't produce his Aadhaar card, nor does he produce his
I
caste
produced.
certificate, which says, my lord, that he belongs to Pandupura, my lord, Mandya district. They have called, my lord, for training in Mysore district.
Is a
Therefore,
bar
my lord,
council itta idu.
How-
That
how-
stipend.
how- He belongs to the Mandya district, my lord,
Where
so
is
he is
the-
not entitled.
ಎಲ್ಲಿದೆ?
annexer F, E, F.
ಮಂಡ್ಯ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ತಗೊಳ್ಳಿ.
ಮಂಡ್ಯ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಲ್ಲಿ ಹೋದ್ರೆ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಎಲ್ಲಿ ನೀವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತೀರಾ ಅಲ್ಲಿ ಅಪ್ಲೈ ಮಾಡಬೇಕು ಅಂತ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಐ ಆಮ್ ಪ್ರಾಕ್ಟೀಸಿಂಗ್ ಅಟ್ ಮೈಸೂರು. ಈವನ್ ಐ ಕಂಪ್ಲೀಟೆಡ್ ಮೈ ಲಾ ಡಿಗ್ರಿ ಇನ್ ಮೈಸೂರು. And the purpose for which the stipend is granted for sustenance in the initial stage. Therefore, I am
In-persons have already
entitled.
been
ಈಗ
selected.
ಆಗೋಗಿದೆ, ಲಿಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆಗಿದೆ.
List ಮಾಡಿದ್ದಾರೆ.
ಲಿಸ್ಟ್ ಆಗಿದೆ, ಬೇರೆಯವರು ಕೊಟ್ಟಿದ್ದಾರೆ.
So I am entitled, my
Entitlement will see. List ಆಗಿದೆ.
reject
ಲಿಸ್ಟ್ ಆಗಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಈಗೆಲ್ಲ. How can we remove someone and put you in there?
ಅವ್ರನ್ನ ರಿಮೂವ್ ಮಾಡ್ಬೇಕು.
ಪಾರ್ಟಿ ಮತ್ತೆ ಇನ್ಯಾರಿಗೆ ಎಕ್ಸ್ಟ್ರಾ ಕೊಡಕ್ಕಾಗತ್ತಾ?
ಕೊಡ್ಬೋದು ಸರ್.
ಎಲ್ಲಿದೆ?
ಯಾಕೆಂತಂದ್ರೆ ನಾನು ಎಂಟೈಟಲ್
ಇದೆ ಎಕ್ಸ್ಟ್ರಾ ಕೊಡ್ಬೋದು ಅಂತ.
ಕೊಡ್ಬೋದು. If notification annexer.
ನೋಟಿಫಿಕೇಶನ್ ಎಷ್ಟು ವೇಕೆನ್ಸಿ ಎಷ್ಟು ಪೋಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರು. Selecting 10 candidates.
10 candidates.
Correct? Now the 10 candidates already selected. You are the 11th man.
ಹೌದು. 11th man ಅಂದ್ರೆ ನಾ ಅಪ್ಲಿಕೇಶನ್ ಇನಿಷಿಯಲ್ ರಿಜೆಕ್ಟ್
ಆಯ್ತು,
ಮಾಡಿದ್ದೆ.
ಈಗ ಈಗ ಬೇರೆ ಕೊಟ್ಟಿದಾರಲ್ಲ ಅವರು ತೆಗೆದು ನಿಮಗೆ ಕೊಡ್ಬೇಕು. ಈಗ somebody has to go out if you are to be sent put in.
My rejection is it is not reasonable. Therefore,
ಆಯ್ತು, reason
let them
reject ಮಾಡಕ್ಕೆ ಹೇಳ.
reconsider.
Reconsider ಮಾಡಿ ಏನ್ ಮಾಡ್ತಾರೆ?
My application rejected.
What is the effect of sir, what is the effect of reconsideration? Somebody has to be sent out. ಹೌದಾ ಇಲ್ವಾ ಹೇಳಿ?
Not necessarily sent out.
ಮತ್ತೆ 10 posts ಅಲ್ಲಿ I direct him to be the 11th man.
In other aspect, I am entitled. Therefore,
ಈಗ somebody has to be sent out.
Not necessarily sent out. They can accommodate me. They can also
How?
provide.
How? Supernumerary selection, na? How? Accommodated. Without sending someone out, how will you be accommodated?
Reason ಅವ್ರು ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
Reason ಬಿಡಿ ಸರ್, ಸೊಲ್ಯೂಷನ್ ಹೇಳಿ.
ಪ್ರಾಕ್ಟೀಸಿಂಗ್ ಅಲ್ಲೇ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿ ನಾವು ಸಸ್ಟೈನೆನ್ಸ್ ಗೆ ಅಂತ ನಾವು
ಸೊಲ್ಯೂಷನ್ ಹೇಳಿ.
ಹಾಕಿದ್ರೆ ರೆಸಿಡೆಂಟ್ ಅಲ್ಲ ಅಂತ.
ಈಗ
ಮಂಡ್ಯದಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ಕೆ ಹೋದ್ರೆ ಮಂಡ್ಯದಲ್ಲಿ
you are not answering the court's question at all. You are going on in the pleading. I am asking you, Now there are 10 posts notified,
Okay.
10 people selected. You are also one of those persons who applied. You are not selected. Those 10% only, if somebody's selection has to be set aside, correct? For you to get in, whose selection do we set aside? Whose selection?
Annexure J notification ಪ್ರಕಾರ
ನಾನು ರೀಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತೀನಿ. ಮತ್ತೆ ಇನ್ನೊಂದು ರೇಟ್ ಪೆಟಿಷನ್ ಅದೇ ಆರ್ಡರ್.
ರೀಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಅವರು
Nothing. We'll see. We'll take it. List the matter on 22nd. Yes. You have no answer. ಯಾರನ್ನ ಆಚೆ ಕಳಿಸ್ಬೇಕು on other things, ಅವ್ರನ್ನ ಒಂದು ಪಾರ್ಟಿ ಮಾಡಿ without hearing them I'll set aside their order, their selection.
ಅವ್ರನ್ನ ಆಚೆ ಕಳಿಸೋ ಉದ್ದೇಶ ಇಲ್ಲ. ನಮಗೂ
ಉದ್ದೇಶ ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಆಚೆನೇ ಇರಿ. Yes.
Further hearing at 12 PM, till number 72.
Led by Mr. K.G. Raghavan, my lord, he's
Yes.
just on his way.
On his way? Coming?
Yes, my lord, he's coming.
It's on his way. He'll be here in a moment.
So, I'll take the next matter. One takshana will take.
Very well.
Continued 17.
Please, sir.
These are all compensation cases.
No, my lord.
Mata? In drawing up lines then.
My lord, no, my lord, they are felling the trees, my lord, it is a buffer zone. Within, my lord, central government has.
Objection ಹಾಕಿದ್ದೀರಾ?
ಇನ್ನ ಹಾಕಿಲ್ಲ. ಇನ್ನ ಇನ್ 2 ಕೇಸಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡಿ ಕಾಪಿ ಕೊಡಿ first. I'll vacate the interim order if copies are not given. Yes.
Only 6, whatever notice.
2 ಕೇಸಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ. 17
Yes,
1
Jafar.
17
ಅಲ್ಲ ಯಾವ್ದು ಇದೆಯೋ ಅದನ್ನು ಇವತ್ತೇ ಇಲ್ಲೇ
ನಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Objections ಅವ್ರು ಮಾತ್ರ ಹಾಕ್ತಾರೆ.
Proceedings are pending before the deputy commissioner.
That is exactly what I said. They would have appeared before the deputy commissioner.
Deputy commissioner, our grievance is they issue notification on 4/3/2024. No, we are not notified. My lord, when we received the notice for payment of determination of compensation, we came to know. Then we filed our objections. It is at that stage we are praying that, my lord, now it is a buffer zone. My lord, the central.
No, if you have filed your objections before the deputy commissioner, he will consider it and pass on.
Appropriate orders.
My lord, we have given representation to the central empowered committee also, wherein, my lord, in similar case, my lord, in T.N. Godavaram's case, there was a direction to shift the line or to make alternate arrangements.
ಆಯ್ತು, ಎಲ್ಲರೂ shift the line ಕೇಳ್ಬಿಟ್ರೆ ಲೈನ್ ಹೋಗಲ್ಲ.
Already there is an express, my lord, line is there, my lord. They have to.
No, you have to file your objections, one thing. And if matters is before the deputy commissioner, we'll direct him to pass orders.
Yes, sir.
Let them.
ಅಲ್ಲ, ಯಾರು deputy commissioner ಮುಂದೆ objections ಹಾಕಿದಿರಲ್ಲ.
All the objections, whatever it is,
For the deputy commissioner.
Ask deputy commissioner to pass orders on the objections and place the order here. Yes,
we may permit it to file additional objections.
Where, sir?
Before the deputy commissioner.
ಮಾಡಿ additional. I will direct the deputy commissioner to close the proceedings. Till then, they will not precipitate. That's all.
Place that the deputy commissioner takes a vision. We can't execute the work.
No, they are
obstructions.
What is this?
No, they are.
ಆಯ್ತು, DC ಮುಂದೆ ಇದ್ಬಿಟ್ಟು ಇಲ್ಲೂ ಬರೋದೇನಕ್ಕೆ?
ಅಲ್ಲ, ಇಲ್ಲಿ ನಾವು ನೋಟಿಫಿಕೇಶನ್ ಅನ್ನು ಕ್ವಶನ್ ಮಾಡಿದ್ದೇವೆ. ಮನೋಡ ಶಿವಮೊಗ್ಗದಲ್ಲಿ ನೋಟಿಸ್ ಮನೋಡ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಳ್ತಾರೆ. We are residents of ಮನೋಡ ಚಿಕ್ಕಮಗಳೂರು.
ಆಯ್ತು, ಈಗ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ಈಗ ಇನ್ನು ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ವಾ, ಇನ್ನೂ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ. We will direct the deputy commissioner to dispose the matters after hearing all of you. That's where this court can interfere with all this.
Only respectful submission is, my lord, there are lot of forest trees. If they have to be cut, my lord.
Not to precipitate.
Where in
the environmental impact also have you assessed?
Yes, it is there, my lord. It is there.
Forest officer also called upon the meeting before the deputy commissioner.
Forest they have not taken. NOC, my lord, they have not taken. It's a reserve forest. Reserve forest.
Permission is concerned.
So we have given representation to the, my lord.
Sorry. That forest officers also appeared before the deputy commissioner. They have also summoned so far as the deputy commissioner. All of them has been conducted meeting.
Before initiating action.
ಅಲ್ಲ, ಆಯ್ತು, ಈಗ ಆಕ್ಷನ್ ಇನಿಷಿಯೇಟ್ ಆಗಿದೆ, ಸ್ಟೇ ಆಗಿದೆ.
Please.
So let the deputy commissioner hear everyone, and then we'll direct him to pass orders. We'll keep this petition pending. Or we'll dispose this petition, directing the deputy commissioner to take action.
But it may be kept pending and let the deputy commissioner, my lord, environmental aspect and my lord, we will file additional objection also.
Then we'll do it this way. We'll reserve liberty to approach this court again.
Yes.
Let the deputy commissioner decide.
Yes.
Decide after hearing you and also assessment of environmental aspects.
Yes.
That's all. We'll close that on that ground.
Yes, my lord.
Till
If
then,
the-
let
if the
them
writ
not-
petitions are
Till
kept
then
pending,
they
my
will
lord,
not.
then the deputy commissioner not be free to pass an order because the
If
matter
the
will be
petition
pending.
pending is right, won't be
It- ಅವ್ರು
correct.
ಮಾಡೋದಿಲ್ಲ.
We will dispose the petition.
Yes,
We
with
will
the
direct
direction
him to
to-
pass orders and then close it.
My lord, we may be permitted to file additional.
To
objection.
file, yes. The petition, ಎಲ್ಲ ಒಂದೇನಾ ಇದು?
ಎಲ್ಲ.
The petitioners in all these cases are landowners who are now at the doors of this court seeking as a calling in question a notification dated 4/3/2024 and have sought a consequential direction by issuance of a writ in the nature of mandamus, directing the respondent to consider the objections filed before the deputy commissioner on 26/12/2024. The learned senior counsel.
May I place one decision, my lord?
ಅಲ್ಲ ಅಲ್ಲಿಗೆ ಕಳ್ಸೋದು ಬೇಡವಾ?
ಅಲ್ಲ ಕಳಿಸಿ.
ಕೊಡಿ ಅದು ಕೊಡಿ.
Please.
Yes. The petitioner is said to be the owner of the property which has now become subject matter of acquisition for the purpose of drawing up power lines.
There is no acquisition, the right of way.
Right of way, sorry. The petitioners are owners of the property whose right of way is now being taken away by the respondents for drawing up of power lines. The petitioners are, all these petitioners are before the deputy commissioner for having filed the objections for consideration of their cases. It is the case of the petitioner that the petitioners are all residents of Shimoga, na?
Chikmagalur.
Of Chikmagalur district, and a paper publication is issued in Shimoga district, and the lands, the petitioners' lands which are in Chikmagalur district are now, Chikmagalur district are now become the subject matter of drawing up of lines and the right of way being taken away. The learned counsel H.V. Devaraj would submit that all these objections are now taken before the deputy commissioner, and the matter, deputy commissioner is seized of the matter. It would seized of the matter. In that light, I deem it appropriate to permit these petitioners to pursue the remedy, pursue the proceedings before the deputy commissioner by filing additional statement of objections if necessary. It is needless to observe that the deputy commissioner would consider all the objections / additional statement of additional objections that are to be filed before him and pass necessary orders in accordance with law.
Environmental aspects.
In
That forest
accordance
officials
with
are
law.
before the deputy commissioner.
The learned senior counsel submits that the impact on the environment due to drawing up of these lines also should be assessed by the deputy commissioner. It is again needless to observe that the deputy commissioner would after interaction or securing a report from the hands of the forest department would pass necessary orders in accordance with law. With the aforesaid observations, the petition stands disposed till the deputy commissioner would consider the objections and pass necessary orders. No course.
May I make an alternate submission? Report, my lord, we have given representation to the Central Empower Committee also.
Forest department in the Burli.
Please.
So the alle heli alla.
Please.
Till the deputy commissioner would decide the proceedings pending before him, no coercive steps will be taken against these petitioners qua their property. Yes. Ordered
We may
accordingly.
be permitted to place all the materials. Objections plus materials.
ಏನ್ ಬೇಕಾರೆ. Yes.
Oblige.
Next.
The three other petitions which were listed yesterday on the same subject matter.
We will close all that.
I'll move the matter into.
We move those matters, we'll close it on the same order.
This is await service of notice to the respondent.
Huh?
For the petitioner, my lord, this is await service of notice to the respondent 192.
ಒಂದು ನಿಮಿಷ ಏನು ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Yes, my lord.
Shall not, tenant.
Tenant, my lord.
Less the matter of post immediately after service of notice upon the respondents 1 and 2. Next.
My lord, interim order may be extended.
Interim order subsisting will continue to the next date.
My lord.
Krishna and Krishna.
Sharp watch.
Please, my lord.
Premature writ petition is what I had submitted. I'll just point
Last
out.
time court has directed to produce the original records, Lordship.
Let me I submit.
We'll pass it over. There's one time given. Raghavan sir. Yes. We'll take that and then come back.
Further hearing it when?
Lord, this matter.
Learned SG is
False,
leading
my
us. Learned SG is leading us. He's locked in.
All right. Finished, man.
But this matter, my lord, involves the interplay between section 79 and 69A of the Information Technology Act.
Okay. Yes, sir.
And it is our case, my lord, that an independent action under 79(3)(b will not lie.
You'll take an hour?
Yes, ma'am.
1 hour.
Yes, ma'am. It is on interim prayer, my lord, I'll take.
No, what's interim? Ella one there.
No, my lord, they have filed a counter running to about 1,500 pages.
1,500 pages?
Yes, ma'am. The 3 volumes, I think, are the counters. 5 volumes.
All right.
So I think now rejoined actor. So I will show prima facie I am entitled to interim protection. Till, my lord, we are able to file a rejoinder.
Yes, sir. You start.
Therefore, my lord,
On interim prayer 1 hour.
ಈಗ 1 hour ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡ್ತೀನಿ.
All right.
It requires a little bit of
Yes,
examination of the various provisions of the IT Act and, my lord, the judgment of the Honorable Supreme Court in Shreya Singh's case. That, my lord, is the principal point. If I am able to satisfy your lordships, my lord, that prima facie the prayer made by the petitioner is tenable, then, my lord, I am entitled to an interim order of submission. Please look at the prayer, my lord, that we have made in the writ petition. It is a please be kind enough to turn to page 98, my lord.
Headquarters in Texas.
My lord?
Headquarters in Texas.
No, that's all. That's true. That's true.
Hello, that's all right.
That's. But we operate all over the world, man.
Oh, that's Twitter.
And as your lordship knows, my lord, internet today is seamless. Geographical boundaries have no meaning.
Yes.
It can be accessed from anywhere to anywhere, my lord. True, my lord. What your lordship does. My lord, may I show to your lordships, my lord, para 236 of the prayer. Kindly see the prayer that we have made.
Page 236.
My lord, para 236 at page 98. Issue a writ declaring that section 79(3)(b of the Information Technology Act 2000 does not confer authority to issue information blocking orders under the IT Act, and further declare that the information blocking orders can only be issued under 69A of the IT Act, read with the Information Technology Procedure and Safeguard for Blocking of Access Information by Public Rules 2009. That is the blocking rules. Second, my lord, issue a writ restraining the respondents from taking coercive or prejudicial action against X Corp, that is the petitioner before your lordships, its representatives, employees or officers in relation to any information blocking orders issued other than in accordance with section 69A of the IT Act, read with the blocking rules. Issue a writ restraining respondents from taking coercive or prejudicial action against X Corp, its representatives, employees or officers for not joining the censorship Sahyog portal. I tell you lordships what the Sahyog portal, my lord, is. Consequently, issue an appropriate writ quashing those 3 notifications, my lord, where they say we are authorizing so and so, all those officers in terms of section 79(3)(b).
Yes.
Now, my lord, please look at the interim prayer, my lord. And according to me, this interim prayer is innocuous. It does not in any way affect adversely the concern, my lord, that is being expressed by the union. And I would say, my lord, concern which is legitimately expressed by the union. But at the outset, my lord, reason why I say that the concern of the union government, my lord, is legitimate is this. My lord, nobody can say I will act against the laws of this country. Whoever you may be, my lord, if you want to do business in this country, you must do business according to the laws of this country. And insofar as information that is posted on the portal or the platform of intermediary is concerned, the question is, what is the law in this country? That's the question that arises for your lordship's consideration. So, my lord, we don't have to go into, in my humble submission, all that is said, though so much of information is unlawful, so much of information is against the interest of the country, it is against the integrity of the nation, it is against maintaining public peace and order. All that, my lord, according to me, need not even detain your lordships even for a minute, because I think, my lord, we are all on the same side, that nothing can be done which adversely affects the interest of the country, which is not in accordance with the laws of the country. The question, my lord, is what is the law of the country? All that we are saying is that the law in relation to blocking is completely codified in 69A. Please act according to 69A and not otherwise. And 69A has been the subject matter of elaborate discussion by the Honorable Supreme Court in Shreya Singh. And I showed to your lordships. Now, my lord, there is a companion provision. I am using the word companion because this is the word used by the Honorable Supreme Court in Shreya Singh.
79.
79(3)(b). The question, therefore, that arises for your lordship's consideration would be whether 79(3)(b) can be used independent of 69A, thereby thwarting the safeguards in 69A on the basis of which the Honorable Supreme Court upheld 69A.
Yes.
In fact, my lord, before I take your lordships to all that, your lordships may kindly see there is one specific paragraph in the statement of objections which, according to me, clinches the issue. According to us, my lord, Shreya Singhal has laid down the law that 79(3)(b) is a companion provision to 69A. Now, my lord, in the face of this legal enunciation of the law by the Honorable Supreme Court, kindly see what is stated in the statement of objections in paragraph 107.
Statement of objection?
Yes, my lord. It is at page 108, my lord.
Yes.
In the light of what is stated herein above, your lordship got it, my lord?
Yes, yes,
Page
I'm
108,
there.
paragraph
I'm there,
107.
I'm there. Yes. Yes, sir.
In the light of what is stated herein above, and in the context of what would be placed for consideration of the Honorable Court, the law laid down in Shreya Singhal is per incuriam and is not a binding precedent. My lord, the question, my lord, would be, if on the basis of this paragraph, it is now clear that both of us are ad idem, that Shreya Singhal waters down, and it says so in these specific words, waters down the provision, my lord, of section 79(3)(b), upholds, my lord, section 69A. And if it waters down section 79(3)(b) in the context of section 69A, and now they say, no, it is per incuriam, and it is not a binding precedent. My lord, my respectful submission is that plea, I think, my lord, is well established, cannot be raised before this Honorable Court.
Yes, sir.
So, my lord, today we are both ad idem that Shreya Singhal covers the case in my favor. That is why they take shelter under the plea of per incuriam. If it was that Shreya Singhal did not cover the field, as we contend it does, then the question of raising a plea of per incuriam would not have arisen. Now, my lord, please go back to the prayer and see the interim prayer that we have sought for, my lord, if your lordships are kind enough. Please be kind enough to turn to page number 100.
Yes.
It is most respectfully prayed that this Honorable Court may please to restrain respondents from taking coercive or prejudicial action against X Corp, its representatives, employees, or officers in relation to any information blocking orders issued other than in accordance with 69A of the Information Technology Act and the blocking rules framed therein. Look, this is how I ask myself, does this prayer in any manner prejudice the interest of the state? I'm saying we are not preventing you from doing it. Of course you can. Of course there can't be information which is injurious to the interest of the nation. There can't be, my lord, deep fake. Of course, my lord, there can't be deep fake. It is causing great danger. I am not for a moment, my lord, advancing that argument even as a responsible corporate operating all across the world, my lord. It is our philosophy that we will adhere to every law of that country. Deep fake, my lord, is a serious issue. You can do anything in this country today. And I showed your lordships, my lord, all this has been explained very neatly. And I placed that for your lordship's consideration with the Bombay High Court. And in fact, they have analyzed, my lord, what is the role of an intermediary, what is the protection that an intermediary has, what is deep fake. All that has been explained, my lord. I showed that to your lordships, my lord, in a minute. Now, my lord, the prayer therefore is, do not take any action excepting in accordance with 69A. Now, why do I say this, my lord? Let us straight away go to the judgment of the Honorable Supreme Court, my lord, in Shreya Singh. My lord, it is found, my lord, in Annexure A of the petition itself.
Yes, paragraph.
Yes, my lord, it's 2015, 5 SCC, page 1. My lord, if your lordships are kind enough to turn to, kindly turn to page 278. And before I read this, my lord, I want to point out to your lordships that in Shreya Singh's case, 3 provisions came for consideration. One, my lord, is section 66. 66A. The other, my lord, is section 69A. And the third is section 79(3)B. So far as section 66 is concerned, my lord, it was struck down.
Yes, that was struck down.
69A was upheld.
Yes.
79(3)B was watered down, read down. Now, why did they uphold 69A? Why did they read down 79(3)B is what is relevant for the purpose of this case. And therefore, my lord, may I trouble your lordships to kindly turn to paragraph, to page, my lord, paragraph 114. It is available, my lord, at page 278.
278.
Yes, my lord. Yes,
I am there.
Paragraph 112.
Yes, sir.
Section 69A and the Information Technology Procedure and Safeguards for Blocking for Access of Information by Public Rules 2009. Section 69A of the Information Technology Act has already been set out in para 2 of the judgment. Under subsection 2 thereof, the 2009 rules have been framed. Under Rule 3, the central government shall designate by notification in the official gazette an officer of the central government not below the rank of a joint secretary as a designated officer for the purpose of issuing directions for blocking for access by public any information referable to section 69A of the Act. Under Rule 4, every organization as defined under Rule 2G, which refers to the Government of India, state governments, union territories and agencies of the central government as may be notified in the official gazette by the central government, is to designate one of its officers as nodal officer. Under Rule 6, any person may send their complaint to the nodal officer of the organization concerned for blocking, which complaint will then have to be examined by the organization concerned, regard being had to the parameters laid down in section 69A1, and after being so satisfied, shall transmit such complaint through its nodal officer to the designated officer in a format specified by the rules. The reason why, my lord, I am reading in detail the procedure prescribed under section 69A before a blocking order can be issued is because it is on the basis of the inherent safeguards contained in section 69A that 69A was upheld. And now can you say, I will do under 79(3)B what I can do under 69A without the safeguards? That's the point, my lord, that I'm making. Now, my lord, please see what are all the safeguards and 69A. In fact, on the last occasion, my lord, when the matter came up, I gave to your lordship a chart of how, my lord, the whole scheme of 69A works having regard to the blocking rules. Where is that? The chart. We have it. We'll give you extra copy. It may not trouble. No, don't trouble yourself. Don't chart. We'll give it to you. I'll give it to you. Let me read this one and I'll give it to you.
Continue.
We'll give it to you. The designated officer is not to entertain any complaint or request for blocking directly from any person. That is because, my lord, the designated officer has to get it only from the nodal officer. You can't directly go to any officer, to the designated officer directly. The designated officer is not to entertain any complaint or request for blocking directly from any person. Under Rule 5, designated officer may, on receiving any such request or complaint from the nodal officer of an organization or from a competent court, by order direct any intermediary or agency of the government to block any information and part
Who
thereof.
is the designated officer?
My lord, designated officer, my lord, can be a person not below the rank of a joint secretary. There is a
Government,
Yes,
government
some
of
government-
India.
Yes.
Central government employee.
Yes, it is. It's provided for, my lord, under the rules. I showed you the
Right.
rules. Under Rule 7 thereof, the request complaint shall then be examined by a committee of the government personnel who under Rule 8 are first to make all reasonable efforts to identify the originator or intermediary who has hosted the information. If so identified, a notice shall issue to appear and submit their reply at a specified date and time, which shall not be less than 48 hours from the date and time of receipt of notice by such person or intermediary. The committee then examines the request and is to consider whether the request is covered by 69A1 and is then to give a specific recommendation in writing to the nodal officer of the organization concerned. It is only thereafter that the designated officer is to submit the committee's recommendation to the Secretary, Department of Information Technology, which is to approve such requests or complaints. Upon such approval, designated officer shall then direct any agency of the government or intermediary to block the offending information. Rule 9 provides for blocking of information in cases of emergency. Now, this is important, my lord. Rule 9, this is a case where they can do all this almost in the nature of a post-decisional hearing. Rule 9 provides for blocking of information in case of emergency, where delay caused would be fatal, in which case blocking may take place without any opportunity of hearing. The designated officer shall then, not later than 48 hours of the issue of interim direction, bring the request before the committee referred to earlier, and only on the recommendation of the committee is the Secretary, Department of Information Technology to pass the final order. Under Rule 10, in the case of an order of a competent court in India, the designated officer shall, on receipt of a certified copy of a court order, submit it to the Secretary, Department of Information Technology, and then initiate action as directed by the court. In addition to the above safeguards, under Rule 14, a review committee shall meet at least once in 2 months. So, my lord, look at the number of filtration mechanism, because they all recognize, my lord, that this is a very serious intrusion into the right to information. Therefore, my lord, all this is provided for under the statute. A review committee shall meet at least once in 2 months and record its findings as to whether directions issued are in accordance with 69A1, and if it is of the contrary opinion, the review committee may set aside such directions and issue orders to unblock the said information. Under Rule 16, strict confidentiality shall be maintained regarding all the requests and complaints received and actions taken thereof. Learned counsel for the petitioner assailed the constitutional validity of 69A and assailed the validity of the 2009 rules. According to learned counsel, there is no pre-decisional hearing afforded by the rules, particularly to the originator of the information, which is defined under Section 2ZA of the Act to mean a person who sends, generates, stores, or transmits any electronic message, or causes any electronic message to be sent, generated, stored, or transmitted to any other person. Further, procedural safeguards such as which are provided under Section 95 and 96 of the Code of Civil Procedure are not available here. Also, the confidentiality provision was assailed, stating that it affects the fundamental rights of the petitioner. Of course, my lord, one question which arises, which I shall straight away point out to your lordship, my lord, and I shall deal with it: how a company can exercise their rights under Article 19. I will answer that independently, my lord, because according to my submission, my lord, Article 19 is one of the factors for the purpose of Article 14. If something is violative of Article 19, it cannot be in consonance with Article 14. Though they are enumerated as two separate articles under the Constitution. Why?
No. Article 14 pervades to every provision.
Exactly. That's what I'm saying. That's exactly. Though, my lord, I may be able to show in a given case that independent of Article 14, Article 19 is violated, but it cannot be said that Article 14 does not encompass Article 19. It does. So therefore, my lord, the objection that a company cannot invoke Article 19 because you're not a citizen does not hold water, because that's one of the, I'm sure, my lord, one of the things that will be said against us. Now, my lord, please see paragraph 114. It will be noticed that this is a very important paragraph, my lord. It will be noticed that Section 69A, unlike 66A, is a narrowly drawn provisions with several safeguards. That is the reason why 69A was upheld, while 66A was not upheld. 66A was struck down by the Honorable Supreme Court. First and foremost, blocking can only be resorted to where the central government is satisfied that it is necessary so to do. Secondly, such necessity is relatable only to some of the subjects set out in Article 19(2). Thirdly, reasons have to be recorded in writing in such blocking orders so that they may be assayed in a writ petition under Article 226 of the Constitution. The rules further provide for a hearing before a committee is set up, which committee then looks into whether or not it is necessary to block such information. It is only when the committee finds that there is such a necessity that a blocking order is issued. It is also clear from an examination of Rule 8 that it is not merely intermediary who may be heard. If the person that is originator is identified, he is also to be heard before a blocking order is passed. Above all, it is only after these procedural safeguards are met that blocking orders are made, and in case there is a certified copy of a court order, only then can such blocking order also be made. It is only an intermediary who finally fails to comply with the directions issued who is punishable under subsection 3 of section 69A. That's how, my lord, I come in. And I showed your lordship.
You are the intermediary.
I am the intermediary. I showed your lordship the definition. Well, I'll come to this chapter. I am the intermediary. There's no dispute about that. Now, my lord, kindly see 79. Section 79 belongs to, this is important, my lord. Now, their lordships having analyzed the provisions of 69A and the rules framed thereunder, and having noticed the safeguards in section 69A before a blocking order can be issued, violation of which visits an intermediary with serious consequences. Now, my lord, the Honorable Supreme Court is examining section 79. Section 79 belongs to chapter 12 of the Act, in which intermediaries are exempt from liability if they fulfill the conditions of section 79. 79 states, this is important, my lord, permit me to place it for your lordship's consideration. Notwithstanding anything contain any other law of the time being in force, but subject to provisions of subsection 2 and 3, an intermediary shall not be liable for any third party information, data or communication link made available or hosted by him. Now, my lord, this is what is called a safe harbor provision insofar as an intermediary is concerned.
So anything is posted is
yes.
Anything is posted, you come under the umbrella of safe harbor and cannot be.
Yes. Answer is yes, unless there is a blocking order under 69A. If I violate 69A in spite of blocking order, then, my lord, I lose the safe harbor provision under 79. I also become liable under section 69A3. Yes, my lord. The answer to your lordship question. Or there is a court order which is brought to my notice. That's a different court order is a different issue. I am bound to obey. Yes. Now, my lord, if there is a blocking order issued in terms of section 69 capital A and I don't obey it, I am faced with two consequences. One is the punishment under 69A3. Second, I lose the safe harbor provision under 79. And this has been, in fact, my lord, this has been explained also by the Honorable Supreme Court and also by the Bombay High Court. I'll place that for you. 79(1) therefore is a very important protection that is given to an intermediary. Because the reason is this, my lord, it's obvious. Now I have a platform. People can post whatever they want on my platform. I have no control of any censorship on that. Because, my lord, the fundamental principle of all this type of information on the internet is what is called as net neutrality. I, as an intermediary, have no sides to take. Whether that information is true or information is false, I have no control. I don't do any censorship. I don't do any filtering. It's just posted on my website. I just provide a platform. Now, it can't be an unrestricted, unchartered. Therefore, 79(1) says, you will get of course, I'm giving you a safe harbor protection. No doubt about it. But beware, if you violate the provisions of the Information Technology Act, that safe harbor provision is gone for you and you will become liable for all action. For example, my lord, suppose let us assume, my lord, information which is defamatory of somebody is filed on, is posted on my portal. I'm a platform, my lord. I don't do anything else. I mean, I just have a platform. Anybody can come and say whatever they want to say. That's the whole object of net neutrality. So they come and say whatever they want to say. Now, my lord, an order is issued under 69A. saying, no, I have complied with all the procedure. This information that has been posted on your portal or on your platform is injurious to the interest of the nation, falling foul of what is provided for under 69A. I direct you to remove it. I am bound to remove it. There is no doubt about it. Or I am faced with a court order. I am bound to do it. Suppose I don't, then my lord, I become liable to the person who is injured. For example, let us take a defamatory statement. Now, if a defamatory statement is posted on my portal and there is no blocking order. Now, my lord, there is can a prosecution lie against me as an intermediary for the offense of defamation under the then IPC or now the BNSS? Answer is no. I will not be liable.
So according to you, the intermediary cannot be held accountable on any score.
Excepting if there is a blocking order under 69A. Of course, I will be liable.
Your accountability springs only after the blocking order, or you have no, you are not responsible for anything that is posted. The consequence thereof, you are not responsible. It results in unlawful acts, you are not responsible.
Yes. Unless there is a blocking order. Of course, there can be a blocking order. They can in fact do an emergency blocking order.
Say for illustration,
Yes.
by the time the blocking order comes about, on a post that is on Twitter, that is on your intermediate platform,
Damage is done.
Damage happens.
It can, they can pass a blocking order as if it's an ex parte order by a court.
Correct.
Do it, because then what happens is there will be a post-decisional hearing.
So now what you are trying to suggest is that the blocking orders under section 79(3)(b) should be passed after hearing you.
No.
Then
79(3)(b) is not the repository of power. 69A is the repository of power. You can always pass a blocking order under 69A.
section 69A.
Please, you can do it ex parte. And that is because a blocking order passed under 69A, whether it is after hearing or as a part of a post-decisional hearing, is subject to scrutiny through various authorities to find out as to whether that blocking order is justified or not. That is the reason why 69A was upheld. Now, today I ask myself the question, my lord, and I place it before your lordships for consideration.
Yes.
Whether this protection, which was the basis on which 69A was upheld, can be given a go-by through the back door. Now, my lord, 79(3)(b) doesn't have any such protection. There is no review committee. There is no designated officer. There is no committee of secretaries. There is no reason to be given. The whole basis of the judgment of the Honorable Supreme Court in 69A was that there are inbuilt protection in section 69A. And now, what I am saying is supported by the findings of the Honorable Supreme Court in the subsequent paragraphs which I placed with respect to 79(3)(b) itself.
Para 122.
Yes, my lord. Your lordship may kindly now turn to that paragraph. Para 121.
121 and 2. Yes.
May I read para 120 if your lordship permits me,
Yes.
my lord? One of the petitioners' counsel also assailed section 79(3)(b) to the extent that it makes the intermediary exercise its own judgment upon receiving actual knowledge that any information is being used to commit unlawful acts. Further, the expression unlawful acts also go way beyond the specified subjects delineated in Article 19(2). It must first be appreciated that section 79 is an exemption provision. Your lordship asked me a question, are you exempted? Answer is yes, because of 79(1). Being an exemption provision, being an exemption provision, it is closely related to the provisions which provide for offences including section 69A. So therefore, my lord, the two are companion provisions. 69A and 79(3)(b) are companion provisions, is how the Honorable Supreme Court looks at it. I'll show your lordships, my lord, a further discussion on 79(3)(b).
Yes.
Being an exemption provision, it is closely related to provisions which provide for offences including section 69A. We have seen how under 69A, blocking can takes place only by a reasoned order after complying with the several procedural safeguards including a hearing to the originator and the intermediary. My lord, I was reading para 121, my lord.
Yes,
It's a crucial part of this judgment
Yes,
with respect to 79
Yes,
3B, my lord.
yes.
Respectfully. It must first be appreciated that 79 is an exemption provision. Being an exemption provision, it is closely related to the provisions which provide for offences including section 69A. We have seen now under section 69A, blocking can take place only by a reasoned order after complying with several procedural safeguards, including a hearing to the originator and intermediary. We've also seen how there are only two ways in which a blocking order can be passed. One, by the designated officer after complying with the 2009 rules, and the other by the designated officer when he has to follow an order passed by a competent court. The intermediary applying its own mind to whether information should or should not be blocked is noticeably absent in 69A read with 2009 rules. Para 122 is crucial. Section 79(3)(b) has to be read down to mean that the intermediary, upon receiving actual knowledge that a court order has been passed asking it to expeditiously remove or disable access to a certain material, must then fail to expeditiously remove or disable access to that material. This is for the reason that otherwise it would be very difficult for intermediaries like Google, Facebook, etc. Now please add X, my lord, to act when millions of requests are made, and the intermediary is then to judge as to which of such requests are legitimate and which are not. We have been informed that in other countries worldwide, this view has gained acceptance, Argentina being in the forefront. Also, the court order and or notification with the appropriate government or its vigilance must strictly conform to subject matters laid down in Article 19.2. Why, my lord? Because 19.2 is what is incorporated in 69A. Unlawful acts beyond what is laid down in Article 19.2 obviously cannot form part of 79. These two caveats, we refrain from striking down 79(3)(b). Now, my lord, therefore, my lord, this is the enunciation of the law, which the government now says is per incurium, is not binding. My lord, I ask myself, how can it be said to be not binding when that question directly arose for consideration before the Honorable Supreme Court? Supreme Court was considering, my lord, the constitutional validity not only of 69A, but was also considering the constitutional validity of 79(3)(b), and then said, because we are upholding 69A, because of the inherent safeguards contained in 69A, we will read down 79(3)(b) to bring it in consonance with 79A, and therefore I will not strike down 79(3)(b). This seems to be the law. And therefore, my lord, I ask myself, what is the reason why the government seems to think that 79(3)(b), if it is read down in the way in which the Honorable Supreme Court has done, is not enough, is not a binding precedent? Of course it is a binding precedent, my lord. I'm surprised that the government says so before your lordships. And to come and plead before your lordship is per incurium, is unheard of. I think the law is well settled that the High Court cannot hold that the judgment is per incurium. You can always say, if there is a larger bench judgment, your lordships will follow that and not follow the judgment with a lesser quorum. To say that a judgment of the apex court is per incurium is, my lord, a submission which I would respectfully submit, my lord, is not to be countenanced by this honorable court. And if I am right in my submission on that, then, my lord, 79(3)(b) cannot be independent repository of power. Kindly see, my lord, 79(3)(b) has no safeguards at all. And therefore, my lord, what is it that we are saying before your lordships? All that we are saying before your lordship is, please read 79(3)(b) in conjunction with 69A. Let them follow it. And reason why I'm saying so, my lord, it is not mere procedural safeguards, because on a proper understanding of section 79, what is the scope of section 79? Your lordships may now look at 79 for a minute.
Yes.
My lord, kindly see the title to the section.
79.
No, respect. It is exemption from liability of intermediary in certain cases. The whole object of section 79 is not to empower the government to do X or Y, but is in fact to deprive me of a protection that is given. that protection and tells us when that protection will vanish. This is the only scope of 79.
Yes.
Notwithstanding anything contained any law of the time being in force, but subject to the provisions of subsections 2 and 3, an intermediary, thank you, shall not be liable for any third party information, data or communication link made available or hosted by him.
So an intermediary is governed only on section 69A and 79 or any other?
No.
That's it?
Yes.
You don't have regulations?
Well, we have an internal regulations. We have.
No.
We have. Is there any other provision in the statute?
Not
No.
in this statute, but how are you governed? How
I
are
will
you
show-
regulated?
I will show to your lordship.
How is an intermediary regulated?
I will show
It is
you.
under the statute
Yes,
again.
my lord. Yes, my lord. We have a information technology intermediary guidelines and digital media ethics code of 2021. I will show to your lordship.
Yes.
I will show to your lordship that. There's no difficulty. Now, I am now on the primary question as to what is the scope of 79. Can you, by 79, arrogate to yourself, when I say yourself, my lord, the central government arrogate to itself a power? Is 79 a power giving provision? Is it an enabling provision? 69A, of course, is an enabling provision. 79 is not. 79 only says that first, as the title suggests, it gives me an exemption. It says, subject to these two provisions, subsection 2 and subsection 3, an intermediary shall not be liable for any third party information. Therefore, this is what has come to be called in the internet industry, my lord, as a safe harbor provision. 79(1) gives me a safe harbor provision. Now, that safe harbor provision will be taken away if you do not conform to subsection 2 and subsection 3. Now, what is subsection 2 and subsection 3? Your lordship may concede. The first, my lord, subsection 2 says,
Yes.
when the protection will be available.
Yes.
The provisions of subsection 1 shall apply if A, the function of the intermediary is limited to providing access to a communication system over which information made available by third party is transmitted or temporarily stored or hosted, or the intermediary does not initiate transmission, select the receiver of the information, and select or modify the information contained in the transmission. The intermediary observes the due diligence while discharging his duties under this act and also observes such other guidelines as the central government may prescribe in this behalf. The guidelines have been prescribed. That's what I told your lordship to 2021 guidelines.
Yes.
Those are the rules.
Yes.
They are called the guideline rules.
Yes.
Then, my lord, having told your lordships when the subsection 1 will apply, subsection 3 tells your lordships when it will not apply. Now, this is where we are now concerned. We are now troubled by this. This is the provision, my lord. This provision of subsection 1 shall not apply if the intermediary has conspired or abetted or aided or induced, whether by threats or promise or otherwise, in the commission of the unlawful act. Now, my lord, we are not concerned with this. B, upon receiving actual knowledge or on being notified by the appropriate government or its agency that any information, data or communication link residing in or connected to a computer resource controlled by the intermediary is being used to commit unlawful act, the intermediary fails to expeditiously remove or disable access to that material on that resource without vitiating the evidence in any manner. Now, my lord, let us analyze 3B. 3B, my lord, has two components. One, my lord, is upon receiving actual knowledge, and actual knowledge has been interpreted by the Honorable Supreme Court as court order. I am not a judge. My lord, I have thousands and thousands of posts which are put on my platform, and I can't be sitting down to find out whether each post is in accordance with the law of country. Unlawful in some other country. What is unlawful there may be lawful here. Therefore, my lord, there is no way in which I can sit down and find out as to whether something is unlawful in the way posted in the intermediary has, upon receiving actual knowledge, therefore has been interpreted by the Supreme Court to mean court order. Then, my lord, if the court order, I am bound to obey. I am not going to sit in judgment over a court order. There's no way. Or, on being notified by the appropriate government or its agency that any information, data, or communication link residing in or connected to a computer resource controlled by the intermediary is being used to commit the unlawful act. Now, what we are now saying is that this power of notifying by the appropriate government or its agency of any information which is residing in or connected to a computer resource controlled by the intermediary is being used to commit an unlawful act. This notification has to follow the discipline of 69A. This is
So what your suggestion is, a notification or whatever that is issued in 79(3)(b) should be in consonance with safeguards in 69A.
Absolutely.
That is your
That's
submission.
my prayer too. That's why I read to your lordships. I am not for a moment saying that it cannot be done. You can do it, but you cannot read 79(3)(b) as a standalone provision having regard to the enunciation of the law by the Honorable Supreme Court in para 121, where the Supreme Court says that it is closely related to what is provided
No.
for in section
In
69.
page 280,
Yes.
section 79 and the information technology intermediary guidelines rules. Which are these rules?
I should. This is the old rules. Now we have the new rules, 2021 rules. I'll give you a lot.
So this judgment is interpreting the old rule?
No, this judgment is actually interpreting 79(3)(b. It's the same.
All right.
I
Now,
would
where
say,
is the
my lord-
interpretation of the, see, if you see para 119,
Yes, madam. Yes, madam.
assailed rule 3.2 and 3.4.
Yes.
Rule 3.2 and 3.4 of what?
3.2 and 3.4 of the 2011 rules.
11 rules.
Yes, yes.
No, those are blocking rules.
No, intermediary rules.
Intermediate rules,
Intermediate
we have a
rules.
latest one.
These are all not
2020.
That
blocking
is-
rules. Blocking rules are separate.
No,
These-
why am I
I'm
asking
sorry.
this?
I'm sorry.
Shreya Singhal interprets rules of 2011 and the statute is, that's still there. 69A and 79 are still there. But there is a change insofar as it concerns the intermediary rules.
There is
That
some
is,
change.
there is a change which is in
There is some change.
2021.
But my lord, it will not really matter.
I'm just asking
Of course.
to know.
I vote on.
Yes,
I vote on.
yes.
Your lordships are right, my lord. Your lordships are right, my lord, that what was being considered was the 2011 rules in Shreya Singhal, and what we now have is the 2021 rules. Your lordships are right, my lord. But as a matter of fact, what my lord is saying is right, respectfully, my lord. But does it matter to the case? No.
That we'll consider.
That's the point. That's the point. Because basically, my lord, it is an interplay between 69A and 79(3)(b).
No,
79(3)(b) was the same.
The interplay between 69A, no, sorry, I'm just
No, of
getting my doubts cleared.
No, my lord.
Yes.
I will be failing in my duty to my client, my lord, and to this court if I don't answer your lordship's question.
So this 69A and 79A.
79(3)(b).
79(3)(b), the interplay that you're now trying to project.
Yes.
It is to be, that interplay to be considered in isolation or in read in conjunction with any rule.
My lord,
Any
I would
rule
say,
or any rule concerning the intermediate.
my lord, I would say, my lord, it is both.
Now,
It can be done.
these are statutes.
Yes.
The manner in which the exercise of power under the statutes generally will not be there. It will be under the rules.
Yes.
Now, the rules that govern you is the intermediary rules. The intermediary rules that the apex court interpreted is of the year 2011. Now you say it is 2021. What is that governs you in 2021?
2021 rules.
Which is-
And basically, my lord, I can say that there is not much of a difference between the 2011 rules and the 2021 rules. So far, the point I'm making.
All right.
The question as to whether 79(3)(b) gives you an unbridled power to decide what is unlawful, irrespective of what is contained in 69A, independent of the procedural safeguards in 69A, is unchanged. I can quite understand, my lord, if the 2021 rules, unlike the 2011 rules, had also provided for safeguards. Then, my lord, I see what is falling from the honorable court.
Now, what are these 2021 rules?
I should.
Now, this 69, 79 ಆಯ್ತಲ್ಲ?
69.
ಆಯ್ತು.
I just want to show to your lordship on the Bombay High Court judgment, which I'll
yes,
come to
you
your
can.
lordship.
Yes, yes.
Now, let me now show to your lordships, my lord, the rules. My lord, they are called, my lord, the information. My lord, I do not know whether that book will have it.
No,
That book will have it.
What is that called, sir?
My lord, it is called, my lord, Information Technology Intermediary Guidelines and Digital Media Ethics Code.
It's there.
2021. It has, my lord.
Last a little. For a change, it is available.
Some books, my lord,
No,
don't carry
2025 edition. I think. Yes. Now this is Information Technology Intermediary Guidelines, Media Ethics Code Rules 2021.
Respect.
Adeyala?
That's
Yes,
yes,
sir.
yes. Now, my lord, I will straight away go to Rule 3, my lord.
Rule 3. Due diligence.
Yes. An intermediary, including a social media intermediary, a significant social media intermediary, and an online gaming intermediary shall observe the following due diligence while discharging his duties, namely, the intermediary shall prominently publish on its website, mobile-based application or both, as the case may be, the rules and regulations, privacy policy, and the user agreement in English or any language specified in the 8th schedule to the Constitution for access or usage of its computer resource by any person in the language of his choice and ensure compliance of the same. My lord, I must tell you, not just my lord, we have a user agreement. And it is nobody's case that we have violated 3A. So therefore, my lord, it's academic. The intermediary shall inform its rules and regulations, privacy policy, and user agreement to the user in English or any language specified in the 8th schedule to the Constitution in the language of his choice, and shall make reasonable efforts by itself and to cause the users of its computer resource to not host, display, upload, modify, publish, transmit, store, update, or share any information that belongs to another person and to which the user does not have any right, in obscene, pornographic, pedophilic, invasive of another privacy, including bodily privacy, insulting or harassing on the basis of gender, racially or ethnically objectionable, relating or encouraging money laundering or gambling, or an online game that causes harm, or promoting enmity between the different groups on the ground of religion or caste with the intent to incite violence, is harmful to a child, infringes any patent, trademark, copyright, or other proprietary rights, deceives or misleads the addressee about the origins of the message, or knowingly and intentionally communicates any misinformation or information which is patently false and untrue or misleading in nature, or in respect of any business of the central government is identified as fake or false or misleading by such fact check unit of the central government as a ministry may by notification published in the official gazette specify. I want to pause for a moment here, my lord, with your lordship's kind permission, that this B5 was subject matter of challenge before the Bombay High Court.
Oh, this.
Yes, yes.
Oh. All right.
It was struck down. There it came. Yes, my lord. It came before 2 learned judges of the Bombay High Court.
These rules are not there now.
No, this particular one. This particular, not the whole rules.
Rule
only
3.
Only. Rule 3, 5.
3-5 mark.
Yes, attached. Not the whole rules have not been struck down. 3B Roman 5.
3B Roman 5.
Yes.
Only
yes.
that.
Only that. No, in the course of doing that, my lord, the Honorable Bombay High Court has gone in great detail as to what Shreya Singhal has held and how it is to be understood.
That's become final?
No, my lord. I must tell you, I'm told, my lord, what happened, my lord, before the Bombay High Court was it came up before 2 learned judges. Because in the Bombay High Court, my lord, when there is a constitutional validity of a central enactment challenge, it goes before a division. The 2 learned judges took 2 different views, divergent views.
Oh, it's referred to.
And it came before a third judge. The third judge agreed with the view of 1 learned single judge who struck down this.
All right.
So therefore, so far as Bombay High Court is concerned, it is a law
final.
that this rule is no longer there. My lord, I'm given to understand the SLP has been filed and nothing has happened. No? Nothing has happened. I'm just so that your lordships have a complete picture of why I'm going to rely upon the Bombay High Court judgment is in this context. Now, kindly see 5, my lord. Deceives or misleads the addressee about the origin of the message, or knowingly and intentionally communicates any misinformation or information which is patently false and untrue. That is deep fake. Today, my lord, deep fake has become a matter of great concern. I understand, my lord. There's no question about it. You can put anybody's face to anything and then attribute, my lord, some statement that has never been made by that person to that person. That the Honorable Chief Justice of India said, these are the deep fakes that are going on, which is very serious, my lord. Honorable Chief Justice of India said this. It never have been said, but information is there. That's the problem. Deceives or misleads the addressee about the origin of the message, or knowingly and intentionally communicates any misinformation or information which is patently false and untrue or misleading in nature, or in respect of any business the central government is identified as fake or false or misleading by such fact check unit of the central government as a ministry may by notification publish in the field get specified, impersonates another person, threatens the unity, integrity, defense, security or sovereignty of India, friendly relations with foreign states or public order, or causes incitement to the commission of any cognizable offense, or prevents investigation of any offense, or is insulting to other nation, contains software virus or any other computer code, file or program designed to interrupt, destroy or limit the functionality of any computer resource, is in the nature of an online game that is not verified as permissible online game, is in the nature of advertisement, a surrogate advertisement or promotion of an online game that is not permissible online game, or any online gaming intermediary offering such an online game, violates any law for the time being in force. Then, my lord, various other provisions are there which I am not going to detail, your lordships. Now your lordships may kindly go to D, is it? My lord, your lordship may kindly see D also, my lord, for a minute. An intermediary on whose computer resource the information is stored, posted or published upon receiving actual knowledge in the form of an order by a court of competent
Most
jurisdiction.
important.
Most important. Most important. I agree. D is most important. An intermediary on whose computer resource the information is stored, posted or published upon receiving actual knowledge in the form of an order by a court of competent jurisdiction, not an issue at all.
No,
We did
next.
not. Next, madam. Or on being notified by the appropriate government or its agency under clause B of subsection 3 of section 17 of the Act, shall not host, store or publish any unlawful information which is prohibited under any law of the time being in force in relation to. Now, these are the additional words that have been added in the rules. This is identical to what is provided for in 69A. This is the problem that we are having now. Now, if the rules and 79(3)(b has a ground apart from 69A, maybe, my lord, the government would have some argument, but even that is highly doubtful whether by a rules you can provide for curtailment of a right, because your lordship will remember, my lord, the only word in 79(3)(b is unlawful. Now, under the rules, they are expanding the width of all that, all of which is covered under 69A. I ask myself, my lord, if this is the provision of 79(3)(b read with rule 3D, why is 69A required? Now kindly see 79(3)(b, please see this rule 3D in this context. Upon receiving actual knowledge in the form of an order by a court of competent jurisdiction, or on being notified by the appropriate government or its agency under clause B of subsection 3 of section 17 of the Act, shall not host, store or publish any unlawful information which is prohibited under any law of the time being in force in relation to the interest of the sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, in relation to contempt of court, defamation, incitement to an offense relating to the above, or any information which is prohibited under any law for the time being in force. Please compare this with the wording in 69A for a minute.
Identical.
Identical. Now then, if this is the provision under which you will exercise power, then why have 69A? Please see, my lord. Sometimes this rule in certain aspects goes beyond 69A. By a rule, you can't expand the scope of an act. My lord, that's a well-established proposition. That's the point, my lord, that we are making. I am repeating, my lord, and I would like to make that clear before this court, especially appearing for a company like X, that we have no intention of violating any law
That
of
you
the
have
land.
told, yes.
Yes. Now, all that we are saying is here is an exemption that was granted by the statute to me under 79(1). You are saying I will take away the statute without following the safeguard under 69A. Can that be done? And now, my lord, just compare the provisions, my lord, of this rule 3(1)(d) with section 69A.
Yes.
Please compare, my lord. Sovereignty and integrity of the India is found in 69A,
Yes.
which is also found in rule 3(1)(d).
Yes.
Then, my lord, Security of the state is found, my lord.
Yes,
Friendly relations with foreign states is found.
yes,
Public order, my lord, is found.
yes.
Decency and morality, my lord, is not there, but it is added because anyway, my lord, it is it could be, my lord, it is not there in 69A. It could be in terms of public order.
Hmm.
What I ask myself is something extra which you have done in the intermediary ethics rules, which is not covered by 69A. And more importantly, can you by the rules add grounds which are not there in 69A? Because 69A was upheld on the ground, my lord, that all this is covered under Article 19(2).
69A2.
Yes. I'm sorry, my lord.
69A2.
The procedure and safeguards subject to which such blocking for access by public may be carried out shall be such, that is different blocking rules. That's a different rules.
No. Shall be carried out in the manner as such may be prescribed.
Yeah, not these rules, man. Not these rules. They are separate rules.
Which rules?
Oh, that is a different blocking rule. This is the ethics guideline rules. Well, let us not. Oh, I'm sorry, my lord.
No.
I should have.
No. Now carried procedure and safeguards subject to which such blocking
That
for
is
access.
the 2009 rules.
Access by the public may be carried out shall be such as prescribed.
That is the
Now,
2009
the
rules.
that's in fails to.
That is the 2009 rules. That is a different rule, but I'm not for a moment. Now, 79(3)(b) is these ethics rules.
Yes, no
But
problem.
if your lordship can you see the
I'm
2009
get-
rules, so
I quite
that
get
there is
it,
no
yes.
there is no
Yes, no
miscommunication
problem.
from my side, my lord. I want
Yes,
to be
yes,
clear.
no. Anyway, I'm just, yes.
No. The information technology procedure and safeguards for blocking of access information by public rules 2009. That is a different rule. That rule is framed in view of section 69A. No problem. But nobody is now questioning that in view of the fact that these rules have now been because of these, nobody is challenging these rules because of the fact that 69A has been upheld.
Rules were also considered.
Yeah, rules also. These rules were also considered, my lord, in Shreya Singh, right?
Correct.
Yes.
2011
and
rules.
upheld. No, my lord. That, my lord, that is 2011 rules, my lord, is the predecessor to the 2021 rules. This is a different rule. 2009 rules.
If you see page 280,
Yes, my lord.
that Shreya Singhal.
Yes, my lord.
What Supreme Court considers section 79 read with 2011 rules.
11 rules. I am now referring to the 2009 rules.
No, 2011 rules of intermediary guidelines.
That is,
correct?
my lord, having regard to 79(3)(b).
No, I'm only asking. Supreme Court interpreted section 79 at that paragraph at page 280.
Yes, ma'am.
Read with 2011 rules. What are those 2011 rules?
That I'll come to.
Information technology intermediaries guidelines rules
That,
2011.
my lord, is the predecessor
Now
to the
that is
2020
superseded by this code of ethics rules.
2021 rules.
2021 rules.
What your lordships referred
Both
me.
those rules
Yes.
are under section 87 of the Act.
Yes. Yes.
And 87 of the Act read with section 2ZB is prescription of rules. As may be prescribed is what is said in 69(2). Now the prescription is these rules or there are any other rules?
There are other rules.
Which is
Prescription under 69A2 is the 2009 rules.
Which is that?
Well, that your lordship gets it, my lord, in this book. 2000, it's
2009
called
rules.
the Information Technology Procedure and Safeguards for Blocking for Access of Information Public Rules 2009.
All right. Yes.
And this was also considered in Shreya Singh at page 278. If your lordship will kindly see.
Yes, yes.
There are two different things, my lord.
That's true, correct.
My lord,
Now
please see.
69, now two things Supreme Court would consider. 69A read with blocking rules
That is
2009.
2009.
79 read with
2011
80 rules, intermediary guidelines
Well,
rules.
yes, that's therefore, my lord, the two are different. What your lordship referred to, my lord, by inviting my attention, my lord, to section
69(2) is 2009 rules.
2009. Not this. That's all. Now, my lord, I was showing to your lordships, my lord, that ethics rules. I was on rule 3(1)(d).
Yes. 31D. Yes.
Yes, ma'am. Now, my lord, this very rule was the subject matter of challenge before the Bombay High Court.
Judgment of Bombay High Court.
On a Bombay High Court judgment, your lordship will find Kunal Kumra, no?
You,
No, your lordship, no,
Next
no,
week.
Kunal Kumra was a
Oh,
very
this-
famous
yes.
stand-up comedian. He, my lord, was one.
But-
No, this one, no? That's what Kunal Kumra. That's one. I just want to show him the facts. One. My lord, this is the judgment, my lord, of the Bombay High Court. You give a copy. Now, this is the judgment, my lord, of his lordship. Justice Patel, I am mentioning the name only because there were divergence of views.
ಒಳಗಡೆ ರಾಮ್ಲೀಲಾ ಮೈದಾನ ಇದೆ.
ಯಾವ್ದು?
ಈಗ ಕೊಟ್ಟಿದ್ದು ತಗೊಳ್ಳಿದ್ದು.
ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ, ತಪ್ಪಾಗಿದೆ.
ಅಲ್ಲ, ಯಾವ್ದು ಬೇರೆ. ಕವರ್ ಇಸ್ ಕುನಾಲ್ ಕಮ್ರಾ. ಒಳಗಡೆ ನೋಡಿ.
ತಪ್ಪಾಯ್ತಾ?
Don't judge the book by its cover.
Just see the second page. In fact, today, my lord, we come to a stage where don't even go by a judgment that is given across the bar like this, because it could be a artificial intelligence.
You don't know. You don't
My
know.
lord, it's become a serious issue.
Yes,
My lord.
yes.
It's become a serious issue. Some judgments are cited before the court, which are not even passed by the court. So, idu yavdu nambodu yavdu.
That's a disaster of too much
Disaster of-
dependence on AI.
AI, my lord. That's right. That's right. That's the problem with AI now. So we have to be very guarded, my lord. Ultimately, my lord, these are all.
No, that's why I said too much dependence on artificial intelligence will make your intelligence artificial.
Absolutely correct.
That's the problem.
Correct. True.
Yes.
True. Very true, my lord. In fact, my lord, we should not blame the technology, my lord. Technology is like a knife. In the hands of a surgeon, it can save life. In the hands of a murderer, it can take away life.
No, it
the
cuts
mistake,
both
my lord,
ways.
the mistake, my lord, is not in the knife. The mistake is in the user. We have to have our senses to understand, my lord, how far we can use technology. Anyway, my lord, that's.
Yes.
Now, my lord, kindly see just a few paragraphs of the judgment
Yes,
and
yes,
straight away
yes.
come to. My lord, first paragraph, my lord. These cases seem to me to represent an issue of significant immediacy in our times. On the one hand, the seemingly limitless reach and expanse of modes of communication over the internet, especially through social media. On the other, digital technology, the very one that powers the internet, now also allows in a manner and to an extent never known before the manipulation of information, text, graphic, videographic, to generate almost indetectable false information. Information often revealed after the event to be fake. This is far beyond mere forgery. It is something else altogether. An entire chunk of information is manipulated to produce something wholly false. The voice of a famous politician is replicated with words he never spoke. The face of a famous politician is, the face of an actor is superimposed on a body and nobody can tell. This is not parody. This is not a prank. But because these fakes, most especially the deep fakes, where entire videos are conjured up, have such verisimilitude, and because they are too capable of instant global propagation via the internet, their influence is profound. The boundaries between truth and falsehood are blurred, and with that comes the blurring of the dividing line between the constitutional guarantee of the freedom of speech and expression and state-imposed limits on them. After all, who is to decide what is fake and false and what is authentic? Now, my lord, having noticed all this, please be kind enough.
This is Justice J.S. Patel.
This is Justice J.S.
He is the one who
He struck down the
struck
rules.
down.
And the Dr. Gokhale, my lord, she upheld the
Upheld it.
rules. And the third learned judge concurred with Justice
Justice J.S.
Patel.
Patel. Yes.
My lord, if your lordship will kindly see, my lord, on the intermediary, I want to point out, my lord, the court has. Where is that intermediary? Huh? Intermediary. 81. My lord, please be kind enough to turn to 81. If your lordship will be kind enough to turn to 81, no?
Paragraph 81.
81, my lord. My lord, 80.
Safe harbor.
Safe harbor.
Yes, I'm there.
Safe harbor, it is argued, is an important adjunct to free speech in the context of the power to cause harm via the internet. It lies at the heart of the exercise of freedom of speech and expression on the internet. That's very important, my lord. So crucial is the safe harbor provision under 79. It protects not just intermediaries, but through them, their users, precisely those in whom the fundamental right is vested. Intermediaries themselves have no direct interest in any particular user content. Axiomatically, they cannot. It follows that if content publications carries a commercial risk, including a possible loss of safe harbor, it is inevitable that risk avoidance will prevail. Consequently, Mr. Sirwai argues confronting intermediaries with loss of statutory safe harbor is a form of directing or mandating censorship
Yes.
or self-interested censorship if identified online content relating to the business undergarment. An intermediary will do nothing to can do anything. That is very important, my lord. That is why I am affected. I am before your lordships, because a submission is made which I think, my lord, is not tenable in law. Oh, what does it matter to you whether this content is there? It's not there. How does it matter to you? It is a person who is putting must be agreed. Why are you jumping around like this about removal of safe harbor and all that? That is not the issue, my lord. That is, in fact, my lord, hitting at the very foundation of free speech on the internet as incorporated in the Information Technology Act. Online content related to business and an intermediary will do anything to retain safe harbor. It will bend the knee to a government directive regarding content. Its business depends on safe harbor and immunity from prosecution for hosted content. Between safe harbor and users' rights regarding content, the intermediary faces a Hobson's choice. And no intermediary is quixotic enough to take up cudgels for free speech. Compromising one particular chunk of content is a small price to pay. Better the user content is thrown under the bus than having the bus run over the entire business. The safe harbor provision is therefore not just intermediary level insulation from liability. It is an explicit recognition of free speech right. What safe harbor does is to remove the potentiality of indirect censorship. And now para 82 is very important. All this is the contention of the Learned Council. Please see para 82. One line, the Honorable Delhi High Court says, I agree, it cannot be otherwise. And this has been affirmed by the third judge.
Where is that judgment?
Well, that one, right? Third judge. Third judge. And I want to show you.
Where is the divergent opinion here?
Well,
Which
divergent opinion, just go please. No, we will give you separately. This is the judgment of the
this is
learned judge,
this
Justice
is
Patel.
in its entirety is judgment of Justice G.S. Patel.
This is the judgment of our ladyship, my lord, Justice
Gokhale.
Gokhale. Justice Chandurkar. And then, my lord, the concurring view of his lordship, Justice Chandurkar.
Yes, this is reported, is it? Oh, this is the the divergent view.
This is the divergent view. This is the divergent view of her ladyship, Neera Gokhale.
Yes.
She takes a different view.
Yes, yes. So here the petitions are allowed, it is dismissed, and the third judge.
Yes. And the third learned judge, Justice Chandurkar, says, I concur with Justice Gokhale.
Yes, Patel.
I'm sorry, Justice Patel.
Yes.
I'm sorry.
I conclude upon an agreement.
Well, kindly see para 56, my lord.
Yes.
Having considered the matter extensively on the points of difference. Your lordship. Now, my lord, in the opinion of his lordship, Justice Patel,
yes,
I want to show to your lordships a few paragraphs relating to how they construe Shreya Singhal. Kindly see para 83, my lord. No? 83. No? Paragraph 83, my lord, of the opinion of his lordship Justice Patel.
Yes. Now submissions, what remains? Ella agoytu. That's all the submission.
My anxiety, my lord, is that they have found, my lord, the whole scope of the petition has been enlarged unnecessarily. To put in before your lordships, which I think was totally uncalled for. And my lord, it is a serious issue so far as the intermediary is concerned. They have put before your lordships, my lord, material which is obnoxious. And I must say so.
Government of India.
Yes.
All right.
And they have filed R14, no? R15, which is obnoxious.
R15.
Yes. I would like your lordships to see it, my lord. I don't even want to refer to it.
Let's see.
Because my lord, this is nothing that we are going to support. But the only point we are saying is please follow the law. Otherwise, my lord, please amend 69A. Don't provide for the safeguards at all, and then we will test the correctness of 69A. Why get 69A? R16. Well, this is not right. We were told about this now in a counter filed before the, and this is what is troubling us.
Yes.
But we don't support any of this. Let's be clear, man. And we have a difficulty, my lord, even according to our own terms of use, because all this just gives us one, the address of one website. Now, if I go into that and delete one, I can't delete all the 5. I showed your lordships what we have done. I deleted one. I showed your lordship, just show one. And next, if your lordship now sees, is blank. The other 3 will remain. You just can't put one URL address and then say all these URL address refers to all these 3 posts. But how are we going to do this? It's unrelated. And the issue, my lord, is only this much. And the reason why I'm saying I want to file a reply is because of all this. If they are going to not put this, I would not have troubled your lordships with the request for rejoinder. That is why, my lord, in the background of what has been put before your lordships, I told your lordships at the beginning, we don't support such nonsense material. But let us do it according to law. It has to be done in a manner in which I can implement it. My lord, I thought, my lord, the law is well settled, and in many of these aspects where your lordships are looking at a judicial review of administrative action, your lordships will not go into the merits of the case. Your lordships will only look at the procedural aspect of the case, not on the merits, but on how it is done, and I am on how it is done.
Yes.
Now, how it is done is the question, not all this. And I ask myself, what was the relevance of putting all this? And now it is open before a court. And even if I have deleted it, I showed your lordships how it has been deleted. One URL has been deleted. It doesn't mean all those photos go. Those URLs, my lord, one URL does not have half a dozen photos. It has one. I have deleted it. I saw it, my lord. I myself said it is against my terms of use. And I showed your lordship where the terms of use.
Yes.
Give me our terms of use.
No, ನೋಡಿದೆ, I saw it.
ಇಲ್ಲ, terms of use ನಾವು ಹಾಕಿಲ್ಲ.
Terms of use.
ನಮ್ದು.
ಎಲ್ಲಿದೆ ಅದು?
It is not. Of course, we are very sensitive to it.
Other than that, other than R16, what would require a rejoint? Because everything is legal submissions, I guess. After hearing, I think the Solicitor General is appearing in this.
Yes.
After hearing him, we will.
Yes, online.
He's online?
Yes,
he's on.
Yes.
My lord, I must confess, my lord, I have not even had, none of us, my lord, have had the time to individually read this 1,500 pages. We have not been able to have to discuss this together.
I'm not saying you should close it. I'm only saying what would require a rejoinder other than R15 and 16.
I understand, my lord.
That's all.
Even to answer your lordship's question honestly, I must read the whole thing. I have not had time to read it also.
No.
And my learned friends also, my lord, we have been under.
No, I'm not forcing you to
No,
foreclose
I know.
everything. I'm
No,
only asking.
I'm answering your lordship's question honestly.
Yes,
Lord.
yes.
What is it that require? I really don't know. If this is the trend of the statement of objections, and it's disturbing. I don't understand why all this should be put against. But this is mudslinging.
We'll see.
This is mudslinging against us. This is what is troubling us, my lord. And now on this basis, you are now saying, I am authorizing every officer. It could be a station house officer. It could be a tax officer. It could be some village accountant to issue orders under 79(3)(b).
No, there should be delegation of power. There should be a notification. Notification must be there.
There is.
Yes.
That is what we are challenging. That is exact. There is, my lord. There is a notification which says I am empowering a tax recovery officer to issue a blocking order under 79(3)(b).
Is that so?
Yes. Yes, my lord. Please be kind enough to done. This is the problem which we have. Today it is this. Tomorrow it can be a tahsildar. Day after tomorrow it can be a clerk. Is this the way in which such a serious and power under that?
No, nodal officers are notified.
When we see what they've done.
Nodal officers, without notifying nodal officers, how will
Not under 79(3)(b). That's the problem. Kindly
No,
see.
there should be under 79(3)(b) also.
Yes, but who is the nodal officer?
Whoever it is, the government of India has notified nodal officers in terms of the act.
No. That's what we are questioning.
That we'll see.
Well, kindly see that. Well, kindly see 79(3)(b) for a minute again.
Yes.
Give me 79(3)(b). Please see 79(3)(b) for a minute. Please see 79(3)(b). 79(3)(b) does not talk about a nodal officer.
No, as may be prescribed.
No, my lord, kindly see, my lord, I showed you.
If you come to 79.
Doesn't, my lord. I showed your lordship the rules once again.
No.
2021 rules. Please see page 38, my lord, of the writ petition. Upon receiving actual knowledge or on being notified by the appropriate government or its agency. Yes. There is no concept of a nodal officer, which is a concept found in 69A. 69A, my lord, the mechanism is very different. Nodal officer has to write to the designated officer. Designated officer then has to take the opinion of that committee. Thereafter, follow that procedure, come back to the nodal officer, and then there is a provision for review.
All right, we'll hear the Solicitor General.
My lord, so far as, my lord, those two annexures are concerned, they were only by way of illustrations. But I withdraw them, my lord, if that is troubling my learned senior.
Please record. Please record.
Yes.
Please record. That must be withdrawn.
I don't press them. Withdrawn means I won't press.
I respect my learned for the fairness with which he is defending the government.
Yes,
I respect that.
Yes.
Maybe it was filed without his instructions.
As the
No, my lord, it was filed
said,
with my instructions.
It
Will
was
not rely
only
upon it.
illustrative of the fact that your intermediary is being misused.
May I request one thing? It is not merely a question of withdrawing. Please eschew it for the record of this court.
All right.
It is a serious issue, my lord. These are all because when you see that, it is disturbing.
No, there are, sir, I can show you much more than this, which will be more than disturbing.
Maybe my learned is right. Sir, I don't know whether you were there when I made the submission. I categorically made our position clear that we are not supporting any unlawful act. We are only on the question as to how the power under 79(3)(b) should be exercised. We are only on that singular point.
We'll hear. SG sir.
Yes, my lord, my learned friend has
continue at 2:30.
My lord, I have taken note of all my learned seniors' submissions, my lord.
Yes.
If it can be kept on, my lord, any other day, I'll finish my final submissions.
No, the learned senior counsel was saying that he would want to file his rejoinder.
Yes, my lord.
No, my lord, rejoinder provided, my lord, rejoinder for these.
No, sir, I made my position clear that when the honorable.
No. Today he said he is making his submissions on the interim prayer, and he wants to file a rejoinder to the objections filed.
No, my lord, he can't have both, my lord. He can have rejoinder, my lord. He can file his rejoinder. Then I'll rely upon my annexures also. I thought he wants to file a rejoinder because of those annexures.
I want to file my rejoinder because I have not had even an occasion to read the 1500 pages.
All right.
So I don't know what else it contains. This is something that was staring in our face.
No,
But
no,
I don't know what
So
is in
then
this.
he can seek time, Lord. I have no difficulty.
Yes,
Well,
he,
last time
so he
when-
wants to file his rejoinder. We will fix a date. And
Yes,
if you
yes.
serve an advance copy of the rejoinder upon the Union of
Yes,
India.
yes, Lord. But as a
Interim
matter
order,
of,
Lord, your lordship may consider.
as a matter
So
of
interim order,
fact, no, my lord, I will not object.
Then
Lord,
my
as a
lord,
matter
one
of
minute.
fact, as a matter of fact, when I
Yes, sir.
filed my reply,
Yes,
my
sir.
learned senior, my lord, made a statement that no rejoinder is necessary, and therefore I am ready to argue today itself. It was me who requested that don't take my reply so lightly. At least,
That is before he had seen the rejoinder.
Exactly.
So
Exactly.
The moment he saw the rejoinder, he's
give it-
still
give it
saying
a
that
I
I
know,
would
but
read.
I also said, since the rejoinder comes from through such a revered person like Mr. Mehta, my lord, I would like to read it for my own benefit.
no, my lord, my learned friend is
So,
much senior and much
on
revered.
a consensus date, we will fix.
Yes, my lord, it can be heard,
And-
my lord, even for the purpose of interim, my lord, but I would
Interim,
say, my
sir,
lord,
your
now,
lordship have heard me already.
If you want to make submissions, sir, in the afternoon with regard to the interim prayer, I will hear.
no, my lord, I think, my lord, your lordships
It
may
is
keep it
better,
for,
sir, there is nothing, you have left nothing now. You have said everything.
my lord,
He
I
has
think, my
covered,
lord,
he has covered the petition itself.
my lord, to be fair to the court, and I think, my lord, my learned senior also will, my lord, agree. My lord,
Yes.
beyond this, there cannot be anything further for final hearing. I'll also, my lord,
Absolutely,
conclude
that
for
is
final
what,
hearing.
that's what I also said. He has
Instead of,
completed
my
his
lord,
submission.
contesting and fighting on interim stages, let us have a final
There's
verdict.
only one small
Yes, sir.
one small submission I want to make, my lord. I understand, but I owe a duty to the court not to waste your lordship's time
Yes.
over and over again. My
Yes,
lord.
sir.
Arguing on interim and then again.
Yes,
My lord,
it's both same, sir.
I bowed out.
Very fair of my lord.
But only one submission. My lord, your lordships may look at the undertaking that has been given by my learned friend last.
That's correct.
Not
That
the
is-
undertaking. I would say a submission that was made
That's
by.
there. I have recorded it.
There's only one addition, that they should not take any further action. Otherwise, my lord, what am I going to do? If every tahsildar, every clerk, everybody is designated, my lord, where am I going, my lord, in this? This is the only protection.
Can I,
Yes,
my lord, let
yes.
us, my lord, dispassionately try
Yes.
and see, my lord, what can be done, which
Yes.
is apprehended by my learned friend. My lord,
Yes,
the
sir.
ultimate conclusion of the entire scheme of the things which my learned senior had shown is this. My lord, he is an intermediary. He is like a, my lord, notice board in a village.
Yes.
I can go and post some good quotation. Somebody
Yes.
can go and post, my lord, an abuse. Someone
Yes.
can go and quote, my lord, post some defamatory material. He
Yes.
says that I am not responsible. Correct, my lord? That is his case. Now, to protect him, there is a safe harbor clause. Safe harbor clause would mean that if, suppose somebody puts a defamatory post against me, and I file a suit against that gentleman as well as, my lord, X, namely the former Twitter, then they
Yes.
would be protected. They would say that I am protected because of 79A. That stage will come as and when somebody moves the competent court either under the civil law
So
or
nothing
the
has
criminal.
happened today.
Nothing has happened, my lord. The stage at which, my lord, he will have to use the safe harbor clause has not even started. So, my lord,
Yes.
just for the sake
No,
of
that's
it
there.
that we
But
got an
there's one-
interim order is
All right, one.
one thing.
There's one.
Yes, sir.
But now, my lord, what right now the stage is that we can intimate them that this is illegal. I'll have to defend it, my lord, on 19(1)(a) ground, 19(2) grounds, etc., etc. I'll have to show the scheme of the act and, my lord, satisfy the court that this is in a larger public interest and constitutionally permissible. But in the meanwhile, nothing is going to happen. Nothing can happen. Suppose, my lord, my learned friend, say Mr. Kamath files a criminal complaint against Mr.
Then
X.
yes.
Then, my lord, then he will have to serve with notice. He will have to say that I am protected by safe harbor and the safe harbor is not. So it is a far-fetched thing, my lord. So far, nothing has happened. So, my
No,
lord, if your
because
lordship can take it
just
up a
when you
final.
file your rejoinder, we'll fix a date and finish
There is
it
one
off.
other issue, my lord. There is one other issue that I want to flag before your lordships. My lord, they are compelling us to join what is called as a Sahyog portal. Now, Sahyog portal is really a censorship portal.
No,
So
no,
therefore, my lord, we should not be compelled to join that portal. Well, let us stand outside of it. let things.
Now, nothing has
No, my lord,
happened.
if they are in any intermediary.
I am bound to join the
operating in
Sahyo portal
India
now.
will be bound by Indian laws unless the laws are set aside by the competent court, namely your
Yes.
lordships. And joining, being a part of a portal, my lord, is not something, my lord, so grave that you need to have an interim protection. You join the portal, subject to everything will be subject to the outcome. But one thing is clear: if you are operating in India, then my lord, Indian law binds you. You are being
Yes,
bound
we
by
will.
all laws in
Now,
every country. India
now
is no exception.
whatever order is now subsisting, we
Yes.
will continue it till you file a rejoinder and fix a date for hearing. It is
Yes.
not that I'm going to fix it after May. Before the
No.
before the end of this before the end of the month itself, I'll fix a date and we'll
Any
finish it.
earliest date convenient to your lordships and my learned senior, my lord.
Till then, if there is anything, you move the matter. No issues.
My lord, would your lordship give me that liberty, my lord?
That is always there, sir.
No,
I will.
It's always
no,
there.
even SG sir will agree.
That no
that if
Obviously,
there-
my lord, it is always there, my lord. Nobody can prevent.
if there is any action taken, you are at liberty to move the matter.
Correct.
That action has been taken.
No, no action
No,
has
no
been
ac-
taken. Now,
action is
SG
some
sir is saying
proceedings
it
being
is not
filed.
going to be taken. Now, if there is anything done in the interregnum for the next day, between the next date, we will do you move the matter. We will protect you.
Consider.
If there is anything done compelling.
The whole difficulty, my lord, let me just,
No. See,
last time I'll put
now,
my point on
ಈಗ
my
there
fear.
there is an undertaking or a submission made
Yes, it has
on
been
the
recorded.
last occasion.
Mr.
that,
Kamath has given some statement, my lord, I believe.
Yes.
President, we have done nothing which will entitle
that's
the
what-
grant of interim relief.
Yes.
That is what.
So the same thing will continue. Nothing has happened that would entail stalling of or whatever interim order you have sought for. Now, once interim stay is granted, then it becomes difficult to hear the matter. We will hear the matter and close it.
And, my lord, this deserves final hearing.
Yes,
And,
it is. This can't be. It deserves final hearing, and I'll fix it on whichever date both of
But
you would.
can it be
agree.
subject to, my lord, your lordship's convenience and my learned senior's convenience? Can
Yes,
it be
sir.
24th, my lord?
Absolutely.
Wait a minute.
24th will fix it at 2:30.
And if I can request him to serve the rejoinder a little in
Sure,
advance.
yes,
We will do that.
Yes,
We will. We will.
yes, yes.
My lord, and would my learned friend, my lord, agree that that annexure can be withdrawn? Because it's obnoxious
No,
to
no.
put it
That's
as a
yes,
part
he
of
has
it.
already said
Your
it
lordship.
will be.
No, no,
yes.
I
will
I
record.
know, my lord.
I will record that.
I know, my lord, you put it with a, as I say,
That I will. That is
sting
all
in the
right.
tail.
Yes.
But
No, no,
let it be.
what
It's so obnoxious.
what I'm
I-
submitting is, I said if that is the only reason you want to file
no,
a
there are
rejoinder,
other reasons
I
also.
will
That's
withdraw.
why I also asked. Other things are all legally said, and you have answered everything. If R15 and R16 are the only reasons you want to file
No,
rejoinder,
there
he
could be
said he's
others.
going to withdraw it.
But
No, if
any
otherwise,
event,
let it
when
remain.
R15 and R16 are obnoxious, then
You,
maybe
you file
No,
your
my lord,
rejoinder. No problem.
no, my lord, let it remain if he wants to file a rejoinder. I
No,
said
no,
if
I-
that's
I-
the
No, no,
only
rejoinder. I will not.
only a
We will
minute.
eschew it everything later.
Please
No,
eschew that.
Only a minute.
So that
just a-
we are,
will.
the reason is
We will do
very-
that. We will do all of that.
Raghavan sir,
while passing the
Raghavan sir.
final order.
Raghavan sir, I thought you want to file a rejoinder only because of those two
No, sir.
annexures.
I also, in
And
fact,
therefore I said if that is
when
so,
the
I will
question
not
was put
press.
to me, I understand. When the question was put to me by the honorable court as to whether that is the only reason, I said I don't even know because I've not even read that
That's right.
1,500.
That is
Then
why.
let it. Then I would
The
request
reason is
you.
only
We'll
this.
pass.
Lord.
We'll
No, no,
remove
then you
that.
deal with
eschew
those
that.
annexures
All
also.
that as a final order. Not to worry. Yes.
Then let the petitioner
Now,
deal with those annexures
Willful.
also. I would wish them to deal
Yes.
with the annexures.
Yes.
Then, my
Heard
lord, I may not
the-
withdraw the annexures.
Yes, heard the learned senior counsel KG Raghavan appearing for the petitioner, who has made elaborate submissions with regard to the statutory landscape upon which he is wanting to buttress his submission, weigh the prayers that are sought. As also the learned Solicitor General of India, along with the additional Solicitor General of India, the learned senior counsel for the petitioner seeks 10 days time to file seeks 2 weeks time to file a rejoinder to the statement of objections filed by the Union of India. The learned senior counsel would submit that grant of an interim order is imperative in the case at hand. The Learned,
My lord, I think we can agree to go for final disposal rather than invite.
that is what, sir. Grant.
Yes, Lord. No, we can
Since the
agree.
matter,
Both of
since
us
the
can
matter is heard at length, grant of an interim order other than what was observed, other than what was observed in the order dated 17/3/2025 would not be necessary at this juncture, as the matter, the matter is being posted on 24/4/2025, and the understanding is that the matter
With
would be
consent
heard-
of the parties, your lordship.
with the consent of the parties, and the understanding with the consent of the parties is that the matter would be heard finally
Yes.
on 24th. Rather move ಮಾಡಿ, no problem.
Yes. And my lord, let the petitioner
just
deal
want to
with those
file, my
annexures
lord,
also.
No, that will remain. Sorry, sir, you said something?
Let the petitioner deal with those annexures also. Now
Yes,
they are filing
in
a
the rejoinder,
rejoinder.
let
I need not, my lord, withdraw.
I
Then
will,
we
my
will-
lord, but independent of parties, right?
we will
this
do
is
it, but since it is already on record, you deal with that also.
Yes.
My lord, I will. There's no
Yes.
difficulty, my lord. No difficulty. But according to me, my lord, it is polluting the fair records of this court.
No, that is why it becomes a record of the court once I finish the case. We will do it. Yes.
No, I just want to file two documents.
ಕೊಡಿ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟು. Yes. ಅದು ಆಮೇಲೆ
Kindly see what is
ಅದಾದ್ಮೇಲೆ
now, my
understanding
lord, the
so and
blocking
so.
orders is with respect to these.
What is
Go
this?
to your lordship.
ಕೊಡಿ.
This is disturbing us, my lord. This is causing us a lot of.
Yeah, I don't have the, my lord, copy of that, what my learned
No, my
friend
lord,
is giving.
yes, sir. I gave it to my learned friend. My lord, please just turn to page 2, my lord. This is what is sought to be blocked. Now we have an order saying block all this. Mahakumbh Jane ka last option. But all kinds of things, my lord. I didn't even want to read this.
Oh, well.
An angry passenger
we'll pass a
shatters.
I'll
comprehensive
deal with
order,
it.
not
No, let
Yes.
it be given to me. my lord.
Copy, now it is given. Now the SG.
Pass it on.
Yes,
Very-
pass it on. List the,
Let this be a
and
record, my lord. Sorry.
the learned senior counsel files a memo appending to it several posts that are on x.com to be taken and would request the same to be taken on record. The same is taken on record. The ಆಮೇಲೆ heard in part, list the matter on 24th at 2:30 PM for further hearing.
Yes, for final disposal. Obliged to your lordship.
Yes, final, I have already said, my understanding is that it would be heard and disposed.
Obliged
12
to.
noon would be better.
12 noon, all right, 12 noon, no problem.
Last
Yes,
week, sir. All our brother lawyers will be cursing us.
No, this is an important issue.
I know, but it is important.
Yes, yes.
Great.
Obliged to.
Kindly, my lord, can I make a mention?
Yes,
Serial
madam.
number 25, my lord. I've been directed to take notice yesterday, my lord.
Yavudu,
Case
madam?
is posted today, 25, my lord.
Yes, madam.
Can I request for Monday, my lord? The position of the tender process is that they are doing verification today, my lord.
ಅಷ್ಟೇ ಟೆಂಡರ್ ಅವಾರ್ಡ್ ಆಗ್ತಾ ಇಲ್ವಾ?
ಏನಿಲ್ಲ.
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀವಿ. ರಾಜೇಶ್ವರ ಮಂಡೇ, ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ.
My lord, serial number 41. I'm retiring from the case, my lord.
Thank you. Yes.
My lord, that may be recorded, date may be
Why,
fixed so that-
madam? Wait. Yes.
My lordship.
What is the urgency?
41, it is the appointment of SIT for investigation.
No, why are you have made elaborate submissions? Why is that you're retiring now?
My lord, the client wants to engage.
No problem. If you're retiring, I'll appoint you as amicus. Wait, yes.
My lord, serial number 34. We have filed, we have received the petition. We'll file for the objections. Kindly pray for short
No,
appointment.
whoever wants adjournment, you make a mention to the court officer.
Yes.
Dates will be fixed later.
Your lordship, serial number.
Because it is only up to 3:45 today. Reference ಇದೆ. ಅದಕ್ಕೆ whatever is possible, we'll do it. It's already 1:45.
Yes. Your lordship, serial number 43. I am the auction purchaser. On 10th April, they are holding the auction for the land for which I am the auction purchaser.
Again?
So it was, yes, your
Why?
lordship. It was kept on 26th before your lordship, 26th March. Then your lordship kept it today because the auction was on 10th April. So
We'll keep it on Monday.
Or Tuesday, your lordship, because I think Tuesday is 8th.
All right, 8th.
Yes, obliged.
My
And I on
I
board.
also think Tuesday is 8th. We'll take
Serial
it.
number
Lord, 8 there is
37.
some difficulty. 7th, my lord, I appear for the bank.
Seventh.
I come from Bombay, but okay, fine. I'll take.
You appear online.
I'll take 7.
Yes.
Serial number 37.
No, we have just filed NOC wakalat for this.
Who has made a submission? Whom are you opposing?
37, my lord. We are seeking for an adjournment.
One
We have
nimsham.
just filed an NOC wakalat.
One nimsham. What is 37?
For restoration of electricity and water connection.
Ah.
We have just
Who
filed
is opposing for that?
the respondents. We are the petitioners.
Huh.
I have just filed NOC wakalat.
ಈಗ ಇಂಟರ್ಮೋಟರ್ ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ. ಏನಿಲ್ಲ.
ಇಂಟರ್ಮೋಟರ್ ಇಲ್ಲ. ಸರಿ ಬಿಡಿ.
No, the suit for injunction was filed because their interference, they had tried to interfere in the
No,
suit.
I have not passed any order.
No, my lords.
There is no interim
No, my
order
lords.
here. Let it come.
Yes, my lords.
ಆಯ್ತು ಮಂಡೇ ತಗೊಂತೇನೆ.
Yes, my lords. Highly obliged.
Ask him to be relaxed. there.
Obliged, my lord.
Yes.
Submission, shall I make one? The matter has been heard on 8/11/2024, posted reserved for orders.
ಯಾವ್ದು ಸರ್ ಅದು ಕೊಡಿ.
Criminal petition 6965 of 22.
ಏನದು?
Poxco-
ಅದೇ
Poxco matter.
ಪೋಕ್ಸೋನ ಏನ್ ಪೋಕ್ಸೋ ಏನ್ ಪೋಕ್ಸೋ ಯಾವುದು
17
ರವಿಶಂಕರ್ ಅಂಡ್
Yes.
ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಲಕ್ಷ್ಮೀ
Lakshmi
ಅಯ್ಯಂಗಾರ್
Iyengar.
appear ಆಗಿದೆ
Yes.
ಅದ tussle between members of the family.
Yes.
Yes. Monday. Yes. We'll see. ಒಂದು ನಿಮಿಷ. Yes, Bharat.